What have you been doing, mate? I haven't seen you since.
I was at Ingleburn.
Well, welcome everybody to the second hearing of the Standing Committee on Law and Justice's 2021 review of the Dust Diseases Scheme. The inquiry is the follow-up of the 2019 review, which focused on silicosis in the manufactured stone industry. We are seeking to understand what progress has been made to address the issues identified in that review. Before I commence, I would like to acknowledge the Gadigal people, who are the traditional custodians of this land. I would also like to pay respects to elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals present. Today we'll be hearing from a number of stakeholders, including former stonemasons who are living with silicosis, representatives of the Dust Diseases Research and Advocacy Organisations, and the government agencies responsible for work, health and safety and workers' compensation. I thank everyone for making the time to give evidence to this important inquiry. Before we commence, I would like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. A transcript of today's hearing will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. While parliamentary privilege applies to what witnesses say giving evidence today, it does not apply to what witnesses may say outside of their evidence at the hearing. I therefore urge witnesses to be careful about the comments you may make to the media or others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. If witnesses are unable to answer a question today and want more time to respond, they can take a question on notice. Written answers to questions on notice are to be provided within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. In terms of audibility for today's hearing, I remind both committee members and witnesses to speak into the microphones. For those with hearing difficulties who are present in the room today, please note that the room is fitted with induction loops compatible with hearing aid systems that have telecoil receivers. And finally, could everyone please turn their mobile phones to silent for the duration of the hearing. I now welcome our first witnesses. Could each witness, starting from my left, please state their name and position title and swear either an oath or affirmation.
My name's Andrew Cloak. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you so much, Mr. Cloak. Mr. Parker.
My name's Ken Parker, and I swear the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you very much, Mr. Parker.
Parker, pull the mic a little bit closer.
I can do that.
That'll work.
You almost have to speak on top of it for it to work. Could I invite both of you to make a short opening statement? Mr. Cloak, you might want to start first.
Okay. Again, my name's Andrew Cloak, former stonemason of 32 years in the industry, now sufferer of silicosis. I'm stage 3. I've been basically ostracised, demeaned, and basically told that my working life is over. As a father of 5 kids, 4 of which are special needs, that's a hard thing to swallow. If this disease that I have decides to become aggressive to the point where I should be hospitalised, I'm wondering who's going to look after my kids, who's going to be around for them in the future, and who's going to be held accountable for what's going on in the industry at the moment, and it's been going on for quite some time. My first real exposure to silica dust was in a New South Wales TAFE room. Miller TAFE, 1988. They had no courses for stonemasons when I first started. They put us in a room next to the bricklayer section, one fan, one roller door, 14 kids, all chipping away at blocks of sandstone. No masks. It starts from the bottom and it goes all the way to the top. Someone has to be held accountable for this. The engineered stone products that have been brought into this country now, nobody's really looking into what is contained in them. A lot of the product comes from various countries that have been known to hide different materials in their products, import them, or export them, sorry. We import them, we're not made aware of what's in the products, and we use them. The dust created by engineered stone is nothing short of poison. It starts at 90% silica. It's embedded in polymer resins, and who knows what's involved in that. It is worse, or it's on the same page as asbestos, and should be treated the same way. The waste management, it should be treated the same way. They recycle stone out of the stone bins and they crush it and they send it to job sites to use as temporary paths for trucks to run over. I've seen this material in schoolyards. The waste from the slurry from the pits, most companies that I know of, straight in the general waste bin. Straight to the tips. It gets broken up by machinery and is generally then sent back up into the atmosphere. It's poison, and we're sharing it with everyone. There's no excuse for that. There is no excuse for not handling it the same way as asbestos is. I had a job about a year ago driving a truck for a company after my retraining. I had to take a load of asbestos to a tip. This tip was a miniature version of an open cut mine. Driving down. As soon as this stuff came out of the back of the truck, there was a water truck there hosing it off. Straight away they buried it. Why isn't engineered stone treated the same? There's no excuse. There should be no holding back. It has to be dealt with in the same manner. Again, my kids are at school now. One day I might not come home. What questions are they going to ask? And who do they ask those questions to? Thank you.
Thank you, Mr. Cloak. Mr. Parker, can I invite you to make an opening statement as well?
Yeah, interesting. I agree with most of what Mr. Cloak has said. I believe that engineered stone is a serious problem. It should be, in Europe, it's been regulated since 2010, and we're way behind them. It's that much more toxic than the natural stones. I think we should be stuck to be only using natural stones. Either licensed, the companies, I agree that the companies should be licensed. They should be like heavily regulated. Most stone companies are absolute cowboys. It's just a mess. They just push it all the time. I've spoken to a 26-year-old guy who is hoping to get married before he dies. Out of 15 people I worked with, 6 of them have come back with silicosis. I've got a 12-year-old daughter. I'm hoping to see her turn 18. My personal setup is I was tested in 2019 through the mandatory screening by SafeWork. I've got 50% of my lungs left. I've got silicosis, which has progressed into progressive massive fibrosis, which then continues, and you slowly suffocate and die. which is always fun. Currently, I'm on a medication that may stop it, or at least slow it down. But that is basically, I'd prefer something gets done so it doesn't continue like that. There are people I know that are still working in the industry because they have no choice as to what they're going to do if they leave it. So instead of taking insurance or anything like that, they just keep working. And it's just a mess. Any questions, I'm happy to answer them.
Thank you, Mr. Parker. I know Mr. Shoebridge said I'll invite you to start questions first because I know you have to depart quickly.
Can I say to both of you, thank you for your evidence and your courage in speaking out today. We need to hear this from the people working with this stuff. It's actually critical. How long have each of you worked with Engineers Zone?
Since it was released,
How long's that, Andrew?
roughly about 25 years ago, it started to show up.
Has it become more dominant in the work you did over time?
It's overtaken just about everything. Natural stone has made a comeback, yes, but there was one stage that engineered stone was 90% of our work.
Yeah, probably about 2006. It really kicked off in the commercial stuff. The last big job I did before I was diagnosed was 4,000 units at Meadowbank, and they were all engineered stone.
That was 2019.
Yeah, so that was 2016 to 2019, roughly, just that one job.
How much dust was there around?
In what I was doing, because they were laminated, so they were 40 mil bench tops, it's just ridiculous. It's impossible to explain the amount of dust you get off the grinding of it. And where I was working, they were just, we had one room with an open door and they stuck a few fans on the wall and they were just blowing it straight out of a block of units across from them. And it's just, yeah.
And even when it's cut to size, and I assume a bunch of this was cut to size, you're still grinding it and
what they were doing with it, they cut it to size, then, or a little bit oversized. Then it's ground, the surface is just ground underneath, and then you stick it together, and then they recut it and repolish it after that. And it's in that bit that there was just
dust everywhere.
Yeah.
Thank you very much, Mr. Shoebridge. Deputy Chair.
Gentlemen, can I commence sincerely thanking both of you for coming along today. In some sense, the committee, and I speak for myself, not on behalf of the whole committee, but I'm sure there's a sense of this, that we perhaps won't get more important witnesses to this inquiry to hear evidence from. And I genuinely mean that. We're actually going to hear from a lot of witnesses. We have heard from witnesses more today, but in terms of the significance and impact of this inquiry, I think it's, can be said that you both bring utmost significance evidence to the inquiry. And obviously we are all deeply saddened to hear about what the impact of this has been on your lives individually, and of course all the people around you, most closely your family and relatives and friends. You are aware of what we're trying to do with this inquiry in terms of trying to progress this issue to protect workers who have been affected and in terms of looking to the future, workers who aren't exposed but will be working in the industry will be protected. So we're looking back and looking forward. Can I ask that with respect to the exposure you both had, was it in the settings of a factory where there was the cutting of bench tops and other configurations for buildings, or was it also work done at a more boutique level at sites, for example, cutting bench tops that may be placed into a unit or in fact a kitchen?
It was both.
It was both.
Both.
Yeah.
If you had to trim on site to fit a bench top in because it's out of square, there's an end panel that's out of square or something like that, a PowerPoint, something doesn't fit quite correctly, it's got to be done there. The bosses won't let you take it back to a factory and cut it.
No. So your example,
It's pretty much the same.
Yeah. So we have obviously, and we're aware of the mass cutting, the bulk cutting done in what we would call the manufacturing or the cutting sites, and they're sort of standalone sites. But that then runs through to still a lot of cutting that is done at the site level with respect to making alterations or changing to the cut to ensure it fits properly into the actual part of the room or the kitchen, whatever the case may be. Is that right? It's sort of is across that spectrum?
Yes, a lot of them, it's not as much now, but they were doing the sink and cooktop cutouts. With the guys I was working with, they were mostly doing that on site, so they're doing the full cutouts inside the units. So basically you turn that into one seriously toxic box full of dust. And with the cowboy direction of a lot of the companies, masks, dust extractors, fans and things like that don't exist. They just get in there and do it. And the guys, half of them are working for cash and all kinds of things. So they basically, if they don't do it, their jobs are gone. And yeah, it gets rough.
So both of you have had the long-term exposure, which tragically has led to your most difficult circumstances you find yourselves in. The position of the regulator and the government is that satisfactory progress is being made to attend to this issue. In other words, it's now identified as a problem. It's being spoken about openly as a problem, and positive good steps are being made to address it, to deal with it. I just invite both of you from your own respective experiences and perhaps even speaking to others that are still involved in industry to comment on that. Is there change going on that's being claimed?
There has been some change. Where I was working last, they've stopped dry cutting in the factory. Everything's been done wet, as much as can possibly be done. Beyond that, there's supposed to be a ban of dry cutting on sites. I had a house across the road from me that's just had a renovation done. They did all the cutouts out the front.
Dry. Yep.
That's as much change as I've seen.
If you could we'll pass it around, but if you, have you got any observations that you'd like to make?
I've been fairly much completely out of it, but from what I've heard is there's been a lot of companies shut down, the smaller ones that were really pretty wild. There's definitely been a lot of push for everything to be done wet cutting, wet polishing, but as far as the engineered stone, with the silica levels in it, I don't think it's going to change that much. A lot of my damage was, I was a wet polisher for a long time, and from what I've been told, it just means that you're breathing in finer dust particles in the water, and that's why it's done so much damage inside.
Thank you very much. I'm just going to pass to Mr. Amato, then Mr. Roberts, and then I'll come back.
Thank you, Chair. Thank you, gentlemen, both of you for appearing today, and I'd like to echo the words of my colleagues here. We're all here to support you all, and we're all here to also resolve this critical issue we have.
Mr. Amato, could you bring the microphone?
Yes. And can I ask you a question? When did you... Well, I came from an industry where asbestos was a problem. I came from the automotive industry. And I remember when that first came out, we used to blow things out with air. And then we're told you've got to hose it down and so forth. And there was other issues that they didn't raise, like when it goes on the floor, it dries up and obviously it goes everywhere. But when did you first become aware of silicosis? When it first come to your attention, you started hearing about it?
Around about the time that, well, actually, no, that's wrong. We found out about it at TAFE.
Okay.
We were told at TAFE that for a long time, the stonemasons that built the city, that there wasn't a stonemason alive over the age of 60, and they'd all died from sandstone dust.
Okay, now that was back in 1988 in middle of TAFE, as you said. Okay, but the industry itself, so when you went to your place of employment, what did they tell you? Or what sort of precautions did they ask you to take?
They didn't ask us to take any precautions. There were masks, paper masks provided. And it was, if you wanted to wear one, they're in the storeroom. If you didn't want to wear one, you don't have to wear one.
Yeah, okay. And when were you first diagnosed? 2019. 2019, and that's after you became aware of it and they started asking everyone to go and get tested? That's after work cover, Safe Work had a knee-jerk reaction to the rising cases and the deaths in Queensland when they decided to basically raid every factory in New South Wales. They told us we had to go for mandatory testing, and only after I was diagnosed is when which was that day. Yeah, okay. And you're stage 3 now, so can you just tell the community a bit more about stage 3? Well, I'm in the middle. You're in the middle. I'm in the middle. I'm on the same medication as Kenneth. Yep. Hopefully it's going to help, maybe prolong my life. It's a balancing act. I'm walking on a tightrope. Okay. And now you've been retrained. They retrained me to go back into the construction industry. Yeah, okay. My professor was gobsmacked. Cement, all the different kinds of dusts that float around a job site. So did you have a choice about what sort of retraining you were offered? You, as much as you're able to do, however, the building industry is what I was used to being around. Yeah, no, I understand. So for me to move into something else, I'm not computer savvy, so that's pretty much out of the question. I did do a stint a few years back working at nights in a club, but again, with the cigarette smoke in clubs. Yeah, aggravates the problem. Correct. Yeah, yeah. So, yeah, it's either that or drive a truck. Okay. Was any out-of-pocket expenses for you to do that retraining? No. No, that's good.
Mr. Amato, I'm just going to now pass to, I'll come back to you a little bit later. I'll pass now to Mr. Roberts.
Thank you, Chair. Thank you, gentlemen, for giving up your time this morning, and I too echo the comments that have already been passed in terms of your bravery for coming along and giving evidence. And I'll pose a question to both of you. Either or both can answer. You're both very experienced in this industry, been in it a long time. Over that period of time, how many times do you reckon you ever saw Safe Work, or the regulator as it was, because it goes through a number of names, attend the sites that you've been at, either in the factory or on the actual job site itself? I'll start with you, Mr. Cloak. How many times do you reckon you've ever seen them? Once? Once. Once in how many years? 32. Once in 32. Mr. Parker? How many times do you reckon you've ever seen the regulator turn up to inspect safety issues?
Twice, I believe.
In your, how many years are you again?
Started in 1998, I think.
Yeah, right, okay. So twice you've seen the regulator, and Mr. Cloak, once you've seen the regulator.
I did see once a lung bus. I was doing a job on the Chief Secretary's building when they were refitting that. However, that was a government job.
Yeah. But the lung bus, unfortunately, it's not preventative, is it?
They were only there for the painters anyway.
Exactly. So in terms of prevention of this disease, like regulating the industry, you've seen very little regulation
The only
at all.
time I saw Safe Work was when they came in and told us we had to go for lung examinations.
Just, if you don't mind, just for a bit of context, can I ask when each of you finished up working on job sites?
I finished up at the end of, March 2020.
Okay. Mr. Parker?
I was tested at the end of September 2019. I worked for another week and that was it.
All right, thank you.
Mr Roberts, you've still got a call.
I have no further questions.
Okay.
My question's been answered.
Okay,
Thank you, Chair.
I'll go to Mr Martin, then I'll go to Mr Diadam and Mr Buttigieg.
Thank you, Chair, and thank you both of you, not only for making the time, but for coming and sharing your experience. I just want to quickly note, personally, this is a big issue for me. Both my grandfathers died from workplace-acquired lung diseases. One worked on the factory floor at James Hardie and he died with asbestos in his lungs. The other one was a Caterpillar D9 operator and died from lung cancer for all the unfiltered diesel exhaust. So going through this inquiry process for me, I'd really like to find a solution, something that works. Do either of you have any comment to make on the changes made in Victoria, if you're aware of the licensing scheme that they've brought in only at the end of last year, and it's something that's being looked at?
I haven't personally heard of that, but
Okay.
it doesn't sound like a bad idea.
Yeah.
To be honest, I think outlawing the engineered stain completely, as America has in a lot of states and I think a lot of
Yeah.
other places, but that and then just straight up licensing or just full control over everything would be really good because it cuts out on the smaller sort of full cowboy operations where they just, there's no safety, there's nothing, they just
Yeah.
get in it, make some cash and
And my understanding is that's the point of the Victorian scheme, to get rid of the cowboys and the fly-by-night operators. Mr.
that's a really good idea.
Clark, anything to add on?
Again, I'll just mimic what Kenneth has just said. There needs to be really stringent rules. They shouldn't be allowed to buy the material unless they've been, unless they've been licensed to do so. But even then, there are a lot of people out there that won't bother to go and do that. They'll go to a company that is, please go get me a couple of slabs. There's some cash.
Yeah.
Thank you very much.
Yeah. And look, for my next question, I'll apologise in advance, but given you're so brave to be here, it's important to make the point to people who are engaging with this subject who don't really have an idea of what it means to have an acquired lung disease. Are you able to give us a bit of an idea as to your symptoms and your experience with managing these diseases?
I really rarely go through a night without coughing my throat out.
Yeah.
Fortunately, since I've been on this medication, that's decreased quite dramatically. As far as being able to do day-to-day things, I can still mow the lawn. I can still go for a walk. But being stonemasons, we are generally fit guys. It is heavy work. You are pushed to be as quick as you can, especially in Kenneth's situation where they've got thousands of units to do. It's push, 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 let's go, boys.
Yeah.
So in that sense, we can still do certain things. I get tightness in my chest still. It's more for me now, my symptoms seem to be under control.
Okay.
But at the moment, for me, the worst thing about it is the mental state that I'm in at the moment. You heard me before when I spoke about my kids,
Yeah.
and I sleep 2 to 3 hours a night with the worry of what's going to happen.
Unknown.
Thank you. Mr. Parker, anything to add?
I think for me personally, I'm lucky in that I've got family behind me. In that financially, I've been all right that way. I struggle with the whole insurance thing at the moment. They're constantly getting me retested for the same thing. Physically, I struggle to walk and talk at the same time.
Yeah.
Basically, anything that's virtually uphill. So if you walk 100 metres uphill, I have to stop 4 or 5 times. The rest of the time, before all of that, I used to be able to run 5Ks happily, no dramas. And then now it's that, which with the kids gets quite difficult. They're the biggest issues I'm having with it at the moment. I try and ignore most of it the rest of the time. I grew up on a farm out past Bathurst. So my working life was on the farm, heavy lifting, and then in a stone. So basically, at the moment, I'm like a lump.
Thank you.
Yeah, it's hard to explain that. It would, yeah.
All right, thank you.
Yeah, you're right.
I'm now going to pass to Mr. Diadam, then Mr. Buddy.
Thank you, Chair, and I'd also just echo the comments of the other committee members. Thank you very much for coming along and telling your story. It's essential for this inquiry to hear from the people who are directly affected by this horrible disease. Look, I wanted to ask firstly, just, I mean, we get a story that this is a problem of education, that the employers just don't know about the hazards. And that if we educate employers, that this will be a major step forward in terms of improving health and safety in the industry. Do you think that that employers are aware of the hazards
100%.
and know what they're doing?
100% they're aware.
Parker, do you also?
I agree with that. They just don't care. They're making too much money out of it.
And in terms of workers understanding the risks, do you think that workers are properly alerted to the hazards? Like, were you aware of the dangers with engineered stone before you were tested, Mr. Parker?
Not to the extent what they are, no. We were basically led to believe that the engineered stone, or most of the guys I knew, that engineered stone was probably 90% resin and 10% stone. And it's not. It's like 90% silica and a little bit of resin. And it's the silica that's what does it, so.
In terms of when you, perhaps I'll start with both of you about whether you stayed with just one employer or did you move around the industry working for various employers?
I moved around. I've worked for probably, over the time, probably about 6 or 7 different employers. Depending on how much work they had, what my personal situation was. One employer I've worked for on and off for over 15 years, became friends, went to the weddings, helped with the houses, went to the christenings. Now they don't even speak to me, for fear of being sued.
And when you started with those employers, what kind of safety induction was there? Is there any safety induction, Mr. Parker?
No.
Nothing?
The company I originally started with were Reasonable. They no longer exist, but they were only high-end marble and granite, and they did sort of like 5% of the work volume of these other ones, and then the rest of them just, yeah, there's nothing like that. There's no safety, no nothing. Their opinion is they can just replace the worker.
Can I ask about I think I was interested, Mr. Parker, you talked about that job at Meadowbank. I think either in this inquiry or in a previous inquiry, the master builders gave evidence that, you know, on jobs like that, it's feasible to set up a discrete wet room and to have all the extraction equipment available for a job like that. Well, firstly, do you agree that that would be feasible? And secondly, have you ever had that experience where a wet room's been set up on site?
I haven't had that experience. It's probably feasible, but it would definitely need to be regulated, like to make sure that it was actually used, and it'd have to actually exist and function.
And that wasn't the case at that Meadowbank site, was it?
No, the Meadowbank was just standard.
Just got one more question, then I'll hand to my colleague. I wanted to ask about the support that you've received from iCare. Perhaps if you could tell us a bit about your experience of iCare and whether you think they're appropriately supporting workers who...
No, they're not. Obviously, by the retraining that they had me do, there was no thought invested into it at all to send somebody with silicosis back into the building industry. It beggars belief.
And is the financial support, or perhaps Mr. Parker, if you can...
Financial support. Because of the position I'm in, I don't think retraining's really a lot of an option for me. I'm considered basically finished. I got the first 6 months, which is what they consider their retraining payment, and they did that for me just to make sure it got done, that I was getting paid. And once that's 6, that's on your normal work rate that you were getting. Since then, I've been on $520 a fortnight from them. And that's since 2019, so that's mid-2020. Since then, they've been reviewing it, or is it how they put it or whatever, trying to increase that to give me a normal payment. And it's still ongoing. I've done the same tests repeatedly. I did a stress test, which was failed dismally. And they still just continue thing. Nothing's been said. I haven't heard from them since June last year. It's the last contact I've had from them.
Mr. Buddige.
Thank you, Chair. Gentlemen, I just want to, I guess, try and cut to the chase with what I think's the one of the key problems that's emerging from this hearing. And if you read the submissions from the government authorities, particularly Safe Work, iCare, CIRA, it's all, and I think one of my colleagues mentioned it before, it's all about, look, we get there's a problem now, we're going to educate people, we're going to stop wet cutting, we're going to institute fines. So in other words, a reactive approach, okay? I think this is the third inquiry we've had in as many years. And the inquiry in 2018, there was a recommendation, and I'll read it out for the committee and yourselves, that the New South Wales government introduce a legislative amendment to ensure all manufactured stone fabrication sites and employers are registered with Safe Work New South Wales and will maintain such registration every 12 months and are conducting regular air monitoring and regularly providing the results to Safe Work New South Wales. And further, that a licensing scheme be set up in New South Wales would mean the government would be able to regulate the industry adequately and properly screen workers as well. Now, the government didn't support that recommendation. Do you think that the reactive approach, in other words, education, instituting dry cutting, issuing fines, basically trying to regulate and police the product without stopping it at its source, do you think that's going to be an adequate fix going forward? Is it feasible that that could be the way forward?
No, because there's 90% of the companies that are out there just won't do it. They won't do it. They'd rather just close up, go somewhere else and start up again. They'll do that, then they'll move on, and they'll just leave the people in their wake.
Yeah,
Parker?
I agree with that. It's hypothetically it'd be a good idea, but as far as the engineered stone, it wouldn't be enough. They tend to always find a way around it, and they'll always find a way around it.
So I just want to explore with you, given your practical experience, with the advent, if you like, the remediation method of wet cutting. Is that in and of it, let's assume in an ideal world that everyone was cutting wet and doing all the proper procedures and everything, is that in and of itself enough to stop contraction of silicosis?
It's not, because it's still in the water vapour.
Yeah, and theoretically you're supposed to wear a mask while wet cutting, but you can't. Because once your mask is wet, you can't breathe, so you have to take it off.
Right.
You wear glasses while you're wet polishing. Nah.
Yeah.
I've never seen a pair of glasses with windscreen wipers on them.
Oh, I see, yeah. It's that small practical problem is you can't see what you're doing.
You end up, I've seen guys dressed like fishermen on trawlers.
So
The other part with that too, because it was brought up in that you take the dust home with you.
Yeah.
So one of the ideas was that you should be showering and getting changed at work at the end of each shift and all this kind of things like that. And you'd have to have that kind of set up in any factory that was operating.
My former employer was told to do that. No, never happened. We were supposed to get changed at work. They were supposed to either put a washing machine in, so we would have to do our own washing at work, or the clothes would have to be sent away to be laundered. It's not just that, it's the dust that you drag into your vehicles. When you take it home, you get undressed at home, there's dust on your clothes. It's going to be another case of the asbestos wives.
So in terms of that wet cutting, to the extent that it is effective or is not, did any of you experience any training associated with how to do that from those companies you're employed by? Because you're both relatively recent industry participants. 2020 and 2019, I think, were the years. What's your experience of training in that sort of procedure?
We never had wet cutting when we were at TAFE. The only thing that was ever done wet was when they initially cut the slabs on the saws. Apart from that, everything else was done dry. But again, if you can use your hands, if you can use power tools, to use a wet cutting machine isn't that difficult. You just have to get used to be able to working blind, because as soon as that blade touches the material, it mixes with the water. You can't see what you're doing.
By virtue of that wet cutting, you're actually introducing another hazard into the work process.
I'm sorry, Mr. Buddy, I know we've all got many more questions for both of you gentlemen. Sorry? Yeah, I've got to do the switch over though. And
Sorry.
Do you mind, gentlemen, if we go a couple minutes just past? Are we imposing on you at all?
Not at all.
Okay. In that case, I'm just going to look around my colleagues, Mr. Donnelly.
Gentlemen, can I just ask the question to you both, respectfully, about with respect to the cost of your medication, current and going into the future, whatever that might be. So you're both actually are medicated to deal with this, to hopefully slow down and to retard this terrible disease. So the current cost of your medication now and going into the future, and with respect to other medical costs and care that you may need now and into the future, can you explain to us, are these covered? In other words, are you going to have these respective costs that are going to be borne covered so that you, in fact, don't have to bear the expense?
At the moment, we're not paying for it. I'm not sure if it's actually Holdsworth House, which are the people conducting this drug trial, which is this right here, or if it's the actual drug company. But I've been told that we will never have to pay for it.
So just your circumstances, you are actually currently taking what is in effect a medication that is a trial?
Correct.
To deal with your condition?
Correct.
Yes.
Yeah.
And just
Yeah, currently it's a trial. Apparently it's 3 years, but I think it'll continue. But I think the standard cost of it is approximately $20,000 a month.
$20,000 a month?
I believe so.
Can I just ask a question? Is there any
I
side
believe that's
effects?
what I was told.
You guys suffering any side effects from these trials?
From the medication, it makes you nauseous. It can give you diarrhea, all kinds of things. Basically, when you go on the trial, you get that and a whole heap of anti-nausea tablets. I haven't had too much trouble with it, but I've heard of other people having some struggles with it.
Like yourself?
Diarrhea. And you have to make sure that you eat, and you eat enough. It's more, for me as well, it's more of a psychological thing that I have to remember to take this tablet every day, twice a day. I've got to get up, I've got to eat by a certain time, I've got to take it. That's just another thing that you think about that's on your mind all the time. And whether it works or not, long term, I don't know.
At this stage, you're feeling there's a positive effect. Also, you're saying something earlier on that you seem to be settled down. But what about yourself, Mr. Parker? Is it helping you?
Yeah, well, from the testing, apparently I'm basically stable at the moment. Yeah. So for me, that's keeping me. My other alternative is a double lung transplant. So, and that's still only hoping that works if that does work. But they're kind of my options. So
That's all it does. It just keeps the disease at bay then.
Yeah,
Just so it doesn't progress any further.
Best to slow it down anyway, yeah.
Thank you. So I'm just trying to get an understanding, just for the committee's sake, that's all.
I'm just looking around the committee. I know we are over time, so with that, gentlemen, I pass my heartfelt thanks to both of you for coming to this committee, sharing your experiences, and I know I speak on behalf of all my colleagues here that we wish you the very best for the future. And again, your testimony is valuable for providing insight to us and the people that will read the report that we generate, the experiences that you've had, and hopefully we can look to prevent it from happening to other people into the future. Thank you very much. We'll now just take a very short break while we switch over for the next members to provide testimony. Thank you.
Thank you very much, gentlemen.
What?
Well, welcome back to the second session of today's Dust Diseases hearing. I'll now welcome our second set of witnesses. Could I please invite the witnesses, starting from my left, to state their name and position title and swear either an oath or affirmation.
Yeah, Mr. Chairman, Barry Robson, President of the Asbestos Diseases Foundation of Australia. I solemnly swear, I'll start again.
That's okay.
I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Mr. Robson. Mr. Ty?
Thank you, Chair. My name is Peter Ty. I'm the independent director of the Asbestos Disease Foundation
and I swear that the evidence I'm now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much, gentlemen. Can I invite you now to make a short opening statement, please? I'll start with you, Mr. Robson.
Thank you, Mr. Chairman. I'm here to give evidence to this committee of inquiry into the diseases. With silicosis, once again, coming back to haunt workers in, well, mainly in the state that we're in. The Dust Diseases Board was set up just under 100 years ago because of silicosis amongst workers here in, mainly in Sydney actually, when the train tunnels were being built, you know, the city circle and all that, the sewerage, and workers were dying from silicosis then. So the government at the time set up the Dust Board strictly on that. Then came along farmer's lung from workers being exposed to wheat dust, oats, barley, all that, you know, farm workers being exposed. So that's farmer's lung. And then, of course, later on, the one that I'm more interested in, asbestos. Silicosis, once again, as I said, there's a bit of deja vu. Here we are, nearly 100 years later, discussing it again. The Dust Diseases Board was disbanded and iCare was formed. And I think in the changeover from the old Dust Diseases Board, it wasn't perfect, to what it is now with iCare is chalk and cheese. They've gone, in my opinion, they've gone from being sympathetic or empathetic to workers or victims, as I like to call them. And now it's more like the old insurance model. Get them on the books, get them off the books as quick as possible. And as you heard from these two workers that have been exposed, or two victims now that have been exposed, their trials and tribulations dealing with the mindset of iCare these days. They didn't elaborate on everything that has happened to them since they've been diagnosed, unfortunately. As you can see, with Mr. Clock, it's really affected him mentally, you know, and over the short period of time that I've known Andrew as one of our members, I've seen him gradually, you know, going downhill, you know, can't put it any other way. A very young man with a death sentence. He's got five kids to look after. And it's just, you know, it really, it upsets me to see that a person like Andrew in that situation. And just to re-emphasise my take on iCare and their attitude towards victims, is the retraining. They retrained Andrew as a truck driver. But the industry they put him into, or got him a job in, was the demolition industry. It's full of dust. I mean, it's crazy. And the last one that he didn't go to, they offered him a job sweeping out at a chicken farm, sweeping it out. It's all dust, you know, dried chicken poo. I mean, to me, it's just, they're not on the side of the victim anymore. You know, to me, it's let's retrain them quick as possible. Doesn't matter what it is, as long as we get them off the books. And yeah, so that's my take on it.
Thank you very much, Mr. Robson. Mr. Ty, can I invite you to make an opening statement, please?
Thank you, Chair. My history and background has been to the extent the same as Barry's has been in the asbestos area, but the Asbestos Diseases Research Foundation also has a responsibility for all types of dust, including silicosis and dust which causes black lung. And these are all forms of pulmonary fibrosis, as I'm sure the committee is aware. And the major issue, I think, silica, like asbestos, it's a naturally recurring product, but the diseases caused by utilising those products can be avoided. They are man-made products, asbestos, and the use of asbestos, and of course engineered or compound stone, whatever you want to call it. The prevalence of that in today's building construction industry has caused, I think, something that we've known about for decades and decades, that silica inhaled, and if the inhalation is not controlled, leads to the outcomes that we see today. Worst case scenario, obviously, is death, and there's no reversal. There's medication to ease it, but there's no reversal. So the clear thing in my mind is this is a preventive disease, but to prevent a disease, quite frankly, you have to look at a form of mandation. It's the same thing that we've seen in the asbestos areas where we have licence removalists, where we have provisions in place, and you have to police those provisions. Yes, there's a wonderful code of practice that's been released by Safe Work Australia, and I sat as a member on Safe Work for a number of years, but it's a code. It's advisory, it's guidelines, it's not mandated. And my view is, unless you look, as they've done in Victoria, and mandate and control the industry, then you will not see a decline in the numbers of people presenting with silicosis and eventually dying from exposure to silica.
Thank you very much, Mr. Tai. I'll now turn to questions with the committee. Mr. Shoebridge, would you be in a position to open?
Indeed. Look, thank you both for your work and your ongoing advocacy. I've always found it critical, Mr. Robson in particular. I've always appreciated your advocacy in this space.
Thanks, David.
One of the issues, one of the potential responses is we put in more regulation, we have higher dust standards, we try and enforce a ban on dry cutting, and we try and get out there and regulate the industry to make it as safe as possible. The other option is we realise that we live in the real world, and that no matter how much regulation you're going to put in place, workers will probably still be exposed. Do you have a view about which pathway we should be going down?
Well, I think it should be regulated. I know we can't ban it like we have asbestos into the country, but even that ban, that's a total ban here in Australia, asbestos still manages to get through. So it doesn't matter what regulations you put into place, they'll get round it. I mean, even 2 days ago, what have they found? They've been importing beekeepers' smoking units, for beekeepers. They're full of asbestos, So you can put as many regulations and that in place. And at the moment, and I've got to be critical of Safe Work New South Wales, the policeman is not doing their job.
If there was an option to ban it, though, assuming there was political will to ban it, and assume we could persuade to have some, maybe at a state level, maybe at a national level, assuming the political will was there, would that be a superior option to just to regulating?
A ban, I don't think a ban would work. As I say, it hasn't really worked with asbestos imports. They get round it. I mean, the Sydney ferry debacle, them ferries that were made in Malaysia came here and they had a certificate that said no asbestos. But they can still get round it.
But I know your organisation campaigned for a ban on asbestos and maintains the support for a ban on asbestos, because that keeps 99% of it out, doesn't it?
Oh, yes.
And if that's what we could achieve with a ban on engineered stone, that'd be a better starting point to then police it, wouldn't it?
Oh, I agree with that. If we could ban it, it'd be great. But as I say, they'll still find a way around it.
Yeah,
you know?
the problem's not solved, but it's minimised.
It would minimise it, yes, obviously, you know. But as I say, if that ban goes into place, you've still got to have the policeman there to look after, to enforce that ban.
Well, we've had a ban on dry cutting. There's a lot of work health safety regulations in place. Workplaces are meant to be safe.
Yeah.
What's your view about whether or not that's happening? I might start with you, Mr. Ty, and then you, Mr. Robson.
When you look at the mitigation aspects in relation to silica, I think the issue is the use of engineered stone is very widespread. I think you would find a great difficulty in putting a ban in place. I mean, you go to a block of units, every bathroom, every kitchen is going to have a bench with engineered stone. They're going to have penetrations cut into that. The vanity in the bathroom is going to have that. And there's a variety of different uses of engineered stone for tiling, for decorative features right throughout the building. So the use of it's much widespread. However, when you look at the production of it in a factory area, you can in fact mitigate against the generation of dust. You can ensure that you have wet rooms where cutting takes place. Yes, there are some issues in relation to visual aspects in relation to that. There's also the capacity when these products hit the site, and they've got to be engineered to fit certain circumstances. And when you see multiple high-rises units and you've got contractors in there and subcontractors at a level, that's where it starts to fall apart, because you're getting a situation where stone cutting's taking place and there aren't the appropriate procedures in place. One of the first things that you find when you talk to people in the industry is the operatives in the industry don't understand, and it's not until we've had the publicity in the last 2 years about silicosis. We've had silica around for, 100 odd years in different forms, with stonemasons cutting, with the work that Barry described, but the prevalence of engineered stone has exacerbated that problem. So it's the management of that. I mean, there are extraction vacuum tools that allow you to mitigate against that dust. There are all sorts of things you can do, but the level of education for workers in the industry and for what I describe as cowboys in the industry, some of the majors in the industry understand that, but others don't. And the only way you can do that is have a criteria they have to meet and regularly police it. It's like having road rules without any policemen on the beat to ensure those road rules are adhered to.
We've got that pyramid of how you respond to hazards. And the very first thing you do is remove the hazard. Now, I hear what you say about the ubiquity of manufactured stone, but 25 years ago, we built apartments, we built kitchens, we built commercial properties without manufactured stone. Taking into account that pyramid and how you respond to hazards in the workplace may take a few years, but surely the best response is to remove the hazard.
Well, if in the end of the day you can't control it to the stage where you can minimise a risk, then that's an issue you might have to look with. I mean, the problem we have with asbestos, yes, we've banned the importation, the manufacture, but we've got legacy asbestos that we still have to manage, and that's not managed well, I've got to say. Legacy asbestos are not managed well. The issue with engineered stone is there's an industry out there are contractors out there are people whose income and their businesses are focused on that. My view is that in the event you say, and this is what you should do, we train people now. We're not talking about retraining them as tradespeople. We're talking about what we do with asbestos awareness and other awareness things, where they can do a day's course and say, at the end of the day, self-interest is involved in this. If you don't change the way you do it and your employer doesn't change the way you do it, then at the end of the day, this is likely to be a death sentence for you. Yep. There's nothing like that to focus an individual. And for the employer's perspective, if you don't do what you're supposed to do to ensure there's a mitigation of this, and not an advisory mitigation with guidelines and codes, I'm talking about a criteria that you must adhere to. If you don't do that, then your capacity to run your business will be removed from you. So you need to have those drivers to make sure that there is, in fact, a change in the industry. I accept what you're saying. If you wanted to ban it, problem solved. I think that's a bridge too far.
Yeah. David, can I just ask a very quick follow-up to that, because I think it's an important point that my colleague's making. In an you mentioned the legacy issues of asbestos. The reason it got to that point was because it wasn't banned for so long. So in a sense, in an ideal world, if we were to have the dual response of banning the product and, say, for example, licensing, that would almost cut it off at its mark, wouldn't it? Because if you allow it not to be banned, then you'll have those legacy issues, and then it'll be all reactive for years into the future, forever.
Well, certainly, but I would see the stick that you wave in the air there is to say, if you don't adhere to this and if you don't ensure that people aren't contaminated with this, then what you've got is a situation where you won't actually have a business that operates under engineered stone. But I think, well, I'm sure the committee is aware of it, but the diversity of stone. I mean, we've got paving, we've got tiles, we've got, your bench tops, you've got the rest of it. I just wonder how you could effectively do that, if you put a uniform ban in place. I agree with you that the legacy issue would then be removed into the future. Yep. But it's the management even of our legacy in asbestos that's critical. And I make the parallel there. If you don't manage that legacy asbestos and how it's removed, and that's a whole new question, then you've got an ongoing problem. And who's going to pay for the cost of that problem? I'll tell you at the end of the day, it'll be iCare through a employer subsidy or government at the end of the day. Because as these cases increase and you find that these people can't work, it's an investment, in my view, in solving a greater cost to you in the longer term.
And gentlemen, that actually feeds into something that I've been wondering about, and actually I think you're both experienced enough to help me with, which is actually understanding the product itself. We've heard that it's the next asbestos, and it's been, I guess, throughout the inquiries that we've held, that's been the view put forward by a number of people. I guess in my mind, there's two issues. One, we know that asbestos in, I guess, fibre cement type sheets is I'll say fragile, and when it's damaged, the asbestos becomes friable and can be inhaled. I guess in its inert state, manufactured stone is in effect, a solid, hard product. And seems to be a lot more stable, less of a risk to people, i.e., if somebody has a house with asbestos, they must be careful to make sure it doesn't become friable and scattering, but I think there's less risk with a manufactured benchtop, for example. Just having heard the previous witnesses, though, who said that obviously that product is sometimes then the offcuts are recycled, whether it be for like road base or other matters. It's still broken down, but perhaps in a larger form. And he said, I noticed one of them said that it's potentially even in schools that they've seen that product used. In its either inert form or in a more broken down form, is it safe for the public to be around it, unlike the broken down form of asbestos? Is it only the fine dust that's really the risk? I guess the reason I'm asking this is that people will have stone bench tops and the like in their houses, and hearing that potentially this product has, it causes silicosis, may create some anxiety for people. I'm just curious as to what your experience is with the product and what states it actually creates a risk to people with versus what states it's safe with.
Well, just in relation to that, the key to both asbestos sheeting and engineered stone is the bonding agent. Once something's bonded, it's solid. Yep. In the case of asbestos sheeting, if it's in good condition and it's encapsulated with a PVC paint, provided you don't disturb it, mechanical damage, there are no fibres generated. The difference between and cutting and mechanical damage is the thing that's the issue in both of those cases. So demolition of engineered stone and breaking down of that needs to be controlled. The benefit of engineered stone versus asbestos is you can water quench it, but when it dries out, if it's crushed up and dust residue in relation to silica sits in there, dries out, and then it's disturbed, then it's just as dangerous as the cutting process. So it's a question of how you manage it from the process of installation to complete demolition and where it might be taken at the end of the day for disposal. Asbestos completely, well, not different. Asbestos fibres are so fine you can only see them under an electron microscope, and if there's fibres in the air of this room, it can take 3 days for an asbestos fibre to settle. Yes, the size of, even though you can get right down to a millionth micron in relation to stone. I don't want to go into too much technical detail about it. There's a slightly different issue in it. The problem with manufactured stone is that the product is it's done for purposes of decorative finishes. Someone decides that they don't want their marble bench top in the colour it is. I'm sure a lot of you have partners and someone decides that, okay, the kitchen needs a revamp, we need to come in there, the kitchen bench top, the bathroom needs to do it. The two major areas in a household and the domestic household, and the same in units, are basically the bathroom and the kitchen. That's where the major work takes place. So in the instance that that comes in there, someone says, I'm going to remove your old bench top, you're going to go from a brownie colour to whatever colour, whatever. And it may not have all, in a set of units, you might have an overall design where there is duplication in each of the units and they're done in situ in a factory, they're brought in, installed, they're pre-drilled, the tops are cut out, all ready to go, and there's likely to be limited dry cutting. But there will be some, and you need to do that in a safe way with vacuums, with appropriate masks, time-weighted air monitoring if there's lots of work in there. But the continued use of this in a domestic situation is going to be ongoing. And like asbestos, there has to be some form of control of the substance once it's basically a demolition product and where it's going to be disposed of.
And I'll just add with that, in part of your question, is the home renovation people, the DYO, the weekend warrior. There's no control over them, so that could be already in place, as Peter has just described in the unit or something. That unit's sold, a new tenant takes over, the better half says, I don't like that, remove it, and so they get stuck into it, cut it up, smash it up, So there's that part of the industry also where people can be exposed to this manufactured stone.
Thank you. I know.
One follow up on that.
So yeah, Mr. Shoebridge's got a follow up
15
now.
minutes left of these witnesses.
So, and that's what I was just seeking to do, was to find out exactly who had questions where. So I'll pass to Mr. Buttigieg for the moment, and if other members could indicate if they've got questions.
Look, I won't monopolise the whole 15 minutes because I know my colleagues have all got questions too, but there is a couple of things I want to explore given your subject matter expertise. And I might go to you in particular, Mr. Robson, but also I'm sure Mr. Ty is well across these issues. You mentioned the Dust Diseases Board and how that was fundamentally changed away from, I think, a more sort of personalised case-by-case analysis to, if I could put it crudely, a numbers game.
Yes.
Do you just want to elaborate on that? Because I think that's an important point. I know it's been raised in forums before, but I think it's important we get this on the record.
Okay. In my experience with our members, and I've been involved with the foundation since 1995, so our members under the old dust board, if I could use that terminology, were treated a lot different to what it is happening now. And that's the best way I can describe it. The old dust board, it wasn't perfect by any means, but it was more victim orientated, and because 90% of the victims are widows, and the caseworkers were more empathetic and sympathetic to the widows. Since the Dust Board was disbanded and iCare was set up, the attitude of the caseworkers has completely changed, in my opinion, and in some of my members' opinions. And that's how it comes across. Get them on the books, get them recognised as a victim, do it quickly, get them off the books. Simple as that.
Barry, just in terms of the mechanics, though, of iCare, is iCare the instrument in approving a subsequent workers' compensation claim?
Yeah, all of that.
Yeah.
Yep. It's all involved.
Okay.
You know.
So did that have direct implications on the amount of people able to make a claim?
Well, you're starting to get into the legal stuff now. There is a principle in law that not all victims can get the full compensation. I mean, that's something we've been trying to get rid of for many, many, many years. Currently, our current secretary, she's in that position. She only got some of the compensation as a widow because her husband passed away on the Sunday before his case was heard on the before his case could be registered on the Monday. So she's not entitled to full compensation. I mean, that's one of the anomalies in this, but that's not iCare's fault. That's a legal matter, you know. But
and did the government give you any justification of why they switched away from that more case-by-case personalised approach to the more sort of desktop analysis, if you like, if I could again put it crudely? Was it because of just efficiency, presumably, or?
I can tell you honestly, the day that it was announced, we came in to this house and spoke with the then Treasurer, who's now the Premier, Perrottet, and we sat in his office, and we were strongly objecting to the disbandment of the old board. And he told us that the reason why they did it was that it'd be like a new dawn, that victims would be looked after a lot better, more efficiently, and all the rest of it. And that was straight from the now Premier's mouth. Not only to me, but three widows that were there to witness what he told us, that how good iCare would be in the future. Well, I'm afraid, and I'm not trying to be political, but unfortunately, but that's how it was put to us directly, and that hasn't lived up to that expectation of what he told us that day.
It's okay, Mr. Robertson. This committee's been more critical of iCare probably than anybody.
Oh, okay. Sorry. But I just didn't want to come across as attacking but
I appreciate it.
Just before I move on to Mr. Ty, in relation to research and funding, there was no toing and froing in terms of consultation. It was just a decision was made, and this is how it's going to be.
Correct.
Yep.
And just on the research, the old board had an active research department, and now there's none of that. It's all gone.
Well, I just want to quote to you, or both of you, but from the Safe Work submission into this inquiry, and the title from the submission, it's there in the table document, Supporting Dust Diseases Research and Not-for-Profit Organisations. The Dust Diseases Board has implemented a 2020 to 2024 strategy to guide its vision to make a positive difference to those impacted by hazardous dust exposure and dust diseases. innovation, impact, collaboration and building capacity are the key strategic priorities that underpin their strategy, and the total grant funding is $2.5 million per annum. Then they go on to say the various breakdowns of that funding. Focus, fellowships and scholarship support organisation. Then they say how the total overall funding envelope for the Dust Diseases Board portfolio is $5,645,649. So the government's clearly, the Safe Work are putting a proposition here that this part of the Dust Diseases Board research is adequately, well, significantly funded. I just want to know, at the coalface where you two are involved, how is that funding, if at all, flowing through to what you see?
Well, can I answer that? Because I do sit on the iCare Grants Committee.
Yep.
So 99.9% of that money goes out of New South Wales. I constantly raise on that committee, so I'm on the record, over the last 5 years, about the amount of research money that goes out to every other state in this country, and the minuscule amount that gets granted to research here in New South Wales, where we have our very own research institute that Peter is the chairman of. Yet the money just doesn't flow. And I constantly
I'm
harp
sorry,
about it.
but under what criteria does 99% of the money flow out of the state?
Because it's the grants are voted on this committee that I'm on. We get to vote on each one, as it comes up. That's how it works. So you ain't got the numbers, you don't get the money.
So there's no statutory or regulatory criteria that says that the
objectives are that the research, should be done.
In New South Wales?
In New South Wales, surely. That's been my...
And yet 99% goes into state.
Have a look at the figures. Don't take my word for it. Have a look. As I say, I constantly am on the record at the Grants Committee meeting every 3 months when we meet, and I go through the 20 or 30 grants. You'll see 1 or 2 from New South Wales researchers, the rest all Western Australia, Queensland. They get the bulk of the money. And my question has always been, and I might be a bit dumb here, but it's New South Wales employers' money, workers' comp money, goes into that.
Yeah, that's the point.
Shouldn't it be spent here in New South Wales?
Absolutely.
Where we have a world-leading research centre at Concord Hospital, at Concord, that's struggling for funding in research. I'll leave it there.
I'll come back to you. I know Mr. Amato indicated he's got some questions, so I'll allow Mr. Amato and then any other members.
Mr. Robinson, you're talking about the committee, right? How many people are on your committee?
Oh, God, I think there's about 13, I think.
13, and the grants come up to you, and then the 13 of you decide whether to approve them, accept them, and where it goes.
Yeah, that's how it works.
So those grants there, anybody in Australia...
Anyone in Australia can apply for a research grant, and then it comes before the committee, and we vote on it.
Okay, and you've usually voted against it from going to other states?
I've
been on the record.
I try to. I try to.
Okay. Right.
And I must confess that I've got a bit of skin in the game with the Research Institute. I was one of the founding people that got it up and running, and I was on the board there for 12 years, so I've got a bit of skin in that game. But that's what surprises me when I see that we don't seem to vote that we get grants given to research here in New South Wales. Just shake my head. I'll leave it at that.
And you were on the old board as well. So you were on the board when all the James Hardy issues arose many years ago?
I've been I was a campaigner from day one. It was a 10-year campaign, and I became president of the foundation in 2002, nearly at the start. Well, it had been going a couple of years by then. And then we weren't making much headway in them days against Hardy's because they had a massive PR machine. And as you know, along came Bernie Banton, who was our vice president. And we pushed Bernie as the front man for the campaign, and the rest is history, you know. And that took another 5 years to get Hardy's to the table. And and we got the 40-year agreement, which we're, 13 years into it now, of that agreement for Hardy's to pay for victims. And as Peter sort of indicated in what he said, maybe the same thing might have to happen with this silicosis issue, you know, that there's a levy on employers and companies that to pay for victims. And just something that Andrew said, and I think you asked the question about the medication they're on. They're on a trial medication. We've got the same thing in asbestos areas. There's trial drugs that the big pharma companies will come along to victims and their professors or people and say, look, we've got this experimental drug, we'll supply it for free, but if it was on the market, it'd be $20,000, $50,000 a week or a month or whatever, you know. So Andrew and Ken, and I'll tell you, I only met Ken for the first time today, but I've known Andrew for a while. And that's how they can afford their medication as well, they're guinea pigs basically for the drug companies. Yeah. But that's how expensive the drugs are, even in the asbestos area. Yeah.
Gentlemen,
Thank you.
Sorry,
no, I was going
I'm being too long-winded. But
No, you're not at all. No, I was only just going to impose on you, actually, if you wouldn't mind. I know we are almost at time, but Mr Shoebridge, Mr Diadam and Mr Buttigieg have all got a follow-up question that they'd like to ask. So I was going to impose on you if you might be able to stay for just a couple more minutes after our scheduled finish, just so that they can address the issues. Mr Shoebridge, you've got the call.
Oh, thanks, Chair. Mr Robson, you remember the very real concern when James Hardie was leaving the country, taking its assets off.
Yep.
And the fear was that the survivors of asbestos and the victims of asbestos, James Hardie asbestos, would have nowhere to go because, if you recall, James Hardie didn't have adequate insurance. Remember that?
$2 companies.
$2 companies. And as a result, the agreement was they had to leave billions of dollars here to meet their liabilities going forward. Do you remember that?
I do. My word, I do.
When we're talking about manufactured stone, the largest manufacturer on the globe is Caesar Stone, based in Israel. Do you think we should be particularly wary, given the evidence is they cannot get insurance for product liability for their product? So there's no insurance policy for victims to call upon in Australia going forward, and they have zero assets in the country. Given your experience with James Hardie, what should we do with that information?
Well, I think Andrew mentioned in his evidence that these companies, if they get caught doing the wrong thing, they just close down, start up again under another name, you know. Simple as that. The same basically Hardie's did. Hardie's set up 3 shelf companies, Amacar, Amabar, and I can't remember the other one, and they were only $2 companies. That's all they had, you know, and they moved offshore. These companies will do exactly the same, in my experience.
Well, it's not they will do exactly the same. The current protections for any worker who wants to sue the manufacturer are almost non-existent in Australia. They have no assets in the country and they have no insurance.
That's right.
So what should we do with a product that can't get insurance?
Oh, well, I think you're going back to supporting a ban. I mean, I'd like to see a ban, but I just don't think it'd be practical, really.
Well,
you know.
well, Mr. Tai, if insurers won't touch it, insurers won't insure the product because they can see the damage and the cost going forward. Don't you think that should be an indication to policymakers that this thing is toxic and we shouldn't be touching it?
Well, absolutely. If you can't control and prevent the injury, then basically what you've got to do is, as you say, remove the danger, which is the first step in alcohol safety. The only issue is that I know Caesar stone, which is a major product in there, is we also have quite a bit of engineered stone that's prefabricated in Asia and imported here and then used by smaller contractors, cut and sized and the rest of it. So I'd be concerned about the capacity for someone to sue, and as we find with asbestos, you have to identify, even to get funding under the ASIF funding, the James Hardie Fund, that it was James Hardie that were in fact the purveyors of the product that you in fact were exposed to. And we're seeing that problem emerging now in Australia with legacy asbestos. So, yes, maybe that's what you'd have to do. If you can't control it, then you have to stop it.
Can't control it, can't insure it.
Well, insure it.
Add those two together, at the end of the day, the people who are going to pay the cost and get nothing in return other than what we extract from all other employers through the dust disease scheme are the workers.
Mr. Shoebridge,
should they be paying for a slightly shinier, better coloured benchtop?
Mr. Shoebridge.
That's the question, Mr. Tai, should they?
Mr. Shoebridge, I'm apologise. I'm going to have to pass to Mr. Diadam now.
Yeah. Look, I just want to, obviously, there's a licensing scheme that's being put in Victoria. We have a licensing scheme for asbestos in New South Wales. What lessons can we learn from the licensing scheme for asbestos in New South Wales that might inform policymakers around the introduction of a licensing scheme in New South Wales?
Well, can I jump in first? If you bring in what they've got in Victoria, fine. But it's the policeman on the job. Safe Work New South Wales is very, very slack in this area. We get phone calls at our office about a demolition going on. We tell the people that ring, get in touch with Safe Work New South Wales. 99% that they don't turn up, or they'll tell the people, oh, it's a council responsibility. So the people ring the council say, no, Safe Work New South Wales. So by the time, if they do get there, the job's done. It's finished. The cowboys are gone. Now, that will happen with this, as I think Andrew said, and both Ken said, these companies, they don't care. They don't care.
I think what you've got to do is the two schemes of licensing, you can't compare. The licensing for asbestos product removal is for friable and non-friable asbestos. So it's about removal of legacy asbestos and how it's to be removed. But there are provisions in the Work Health and Safety Act that allow a person in charge of a business or undertaking, because of an exemption that exists in all jurisdictions except for the ACT, to remove up to 10 square metres of non-friable asbestos. You've got a requirement for the asbestos contractors, when they're going to remove quite large amounts of asbestos, to notify Safe Work New South Wales 5 days before they commence that work. Yep. Now, one of the issues is, I think that Barry's raised, is the number of policemen on the job to go out and make sure that that's done properly. But you've also got a situation where, whilst they're waiting for that 5-day period to come in place, a company that wants the building work to move ahead and a company that's prepared to remove that asbestos outside regulation will come in and do that. And if you talk to the industry, you'll find out that's rife. And that's because there isn't policing. So that's removal of a product. What we're talking about here is a licensing system about the installation of a product and the management of people that are involved in it. So that's the education of people who are working in that sector, the education of the person who runs a business, then a criteria, a mandated criteria that says you must do X, Y and Z. And on the overarching part of that is a body that's a police force, really, if you want to describe it, by Safe Work Australia, to ensure that they, in fact, adhere to the mandated requirements. And that's only for the protections. It doesn't take us to where Mr Shoebridge just talked about, because, you know, that means no installation of it. But if you can't get the best in the world, then you have to try and get the second best, in my view. Now, a licensing system in Victoria, and okay, the Victorians made that decision, but you would need to look at something akin to that if you're going to manage a product in New South Wales. We already know, you know, in Queensland, we've got nearly 300 people that have been exposed. They are victims of silica. And can I just say one thing, harking back to the issue of research in New South Wales? That's what my body does. It does research, but it has the broad breadth of all dust diseases. We don't get any funding directly from any form of government. It's all done by philanthropic donation, and we have to find at least $2 million a year. And yes, we apply for grants to the Dust Diseases Board, and we are successful, you know, based on merit on occasions to getting that. But that's a long way away from what we need to run the institute, and it's the only institute that's focused on purely asbestos and other dust diseases.
We have gone quite a bit over time. Mr Buttigieg has a follow-up. I'll ask it to be extremely brief, and if I could ask for some brief responses, if that's okay.
Thanks, Chair. Look, it's an appropriate juncture for me to ask this as a wrap-up question. Are you aware of the McDougall inquiry from April 2021 into Safe Work? Because a lot of what's come out of here is Safe Work's ability or resource to be able to, or will to be able to enforce this. So one of the recommendations to that inquiry was that there be an inquiry into the regulatory and educational functions of Safe Work. Recently in budget estimates, the Minister for Better Regulation would not say whether or not the government intends to carry through that recommendation. I just want to get your view on, because Safe Work in general in terms of enforcement and policing has been an issue not just in silicosis but right across the board. I just want to get your quick views on what appears to be a lack of will to appropriately give Safe Work those powers.
Thank you.
Well, first of all, as I say, I'm very critical of it because I think they're underfunded and there's just not enough of the inspectors on the ground. Simple as that. Simple as that. And as for... they used to have an education committee, and that's sort of gone by the board. And especially in the silicosis area, in this manufactured stone area, a lot of the workers are migrants. They're skilled stonemasons. They've been brought in from overseas. So they won't complain about the working conditions or anything like that because they're worried about their working visa, you know, and so on and so on. So, yeah, I just think that Safe Work is very, very underfunded and not enough policemen on the ground.
Thank you very much, gentlemen, for your appearance today. I'm not sure if any questions were taken on notice, but if they were, they're to be returned within 21 days. We'll now be taking a break for lunch. We're returning at 12:45. Thank you.
Who has lunch at 12:45?
12:45.
We're the best Hansard staff in Parliament.
In Parliament of New South Wales here.
We have the official, and New South Wales has the best Hansard staff in Australia. Welcome to the afternoon session of this Dust Diseases hearing. I'll now welcome our next set of witnesses. If the witnesses from my left could state their name and position title and swear either an oath or affirmation.
Thank you, Chair. My name is Anthony Williams. I'm the Executive Director of Compliance and Dispute Resolution in the Department of Customer Service. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much.
My name is Megan McCool. I'm the Director of Construction Services Group Metropolitan at SafeWork New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much for that. Could I invite you both now to make a short opening statement if you'd like?
Thank you, Chair, and I do have an opening statement which I've already tabled with the Secretariat.
Oh, you're well practiced. Thank you so much.
Thank you. Thank you for the opportunity to appear before the committee today. It's very much appreciated. SafeWork New South Wales, that is the regulator, provided a submission to this inquiry which contains an overview of the progress it has made regarding regulatory reforms, research, compliance, education and the monitoring of dust disease. As you're aware, silicosis is a preventable occupational dust disease caused by the inhalation of very fine silica dust, respirable crystalline silica, or RCS. When exposure is not controlled, however, silica dust is a major hazard to workers in New South Wales. I would like to direct my opening comments on the key achievements and inroads SafeWork New South Wales has made since the first review of the dust diseases scheme in 2017. Our work is guided by the Work Health and Safety Roadmap for New South Wales 2022. Sitting underneath this is the Hazardous Chemical Strategy and then the New South Wales Dust Strategy, which provides a coordinated approach to protect workers from illness, injury and death resulting from the priority dusts being asbestos, silica, wood and other dusts. The Hazardous Chemical Strategy contains 4 components which include awareness, interactions which include securing compliance and workplace visits, research and legislative review. I can report that all 4 components of the Hazardous Chemical Strategy are on track for successful completion later this year, where the strategy will then be reviewed for reset as required. SafeWork New South Wales has also accepted and has implemented Recommendation 1 from this committee's first review of the Dust Diseases Scheme in 2017 by forming the Manufactured Stain Industry Task Force 2018 and 19, comprising of industry, regulatory and workforce representatives, with the majority of its findings capturing trade education, work health and safety and New South Wales Health now in place. We've also implemented Recommendations 3 and 4 from this committee's second review of the Dust Diseases Scheme in 2018 by delivering targeted education awareness and education activities, including a major symposium event, regional roadshow, media campaign and video safety alert, utilising Dr Carl as a spokesman, the development of a national unit of competency by the Industry Skills Council and a local version of the National Clean Air, Clear Lungs campaign in 2021. And silicosis is now being a notifiable scheduled medical condition with the New South Wales Register maintained to link medical practitioners to the work health and safety regime, and an annual report is produced. We've also implemented Recommendations 9, 10 and 11 from this committee's third review of the Dust Diseases Scheme in 2019 by introducing a ban on the uncontrolled dry cutting of manufactured stain through an on-the-spot fine in the work health and safety regulation, in addition to prohibition, that is stop work notices, that can also be applied. Additional SafeWork News inspectors have also been on board with 40 new positions created across Sydney Metropolitan and Regional New South Wales, and the completion of a silicosis case study finding study. SafeWork New South Wales has also been working closely with iCare, CIRA and New South Wales Health and its work health and safety co-regulators, being the New South Wales Resources Regulator and Comcare, as well as doctors, health and industry associations, employers and workers, to reduce dust-related harm and keep workers safe, and will continue to do so. The government also maintains a Silica dashboard on the New South Wales Government website. The dashboard is regularly updated with new figures each quarter on silicosis cases and SafeWork New South Wales compliance activities. advice and guidance for businesses working with Silica is also published on the Safe Work New South Wales website, including translated resources, webinars, safety videos and fact sheets with more than 120,000 views across the Silica web pages and resources to date. New South Wales has adopted the Model Code of Practice, managing the risks of respirable crystalline silica from engineered stone in the workplace, which came into effect in New South Wales on 25th of February this year, and is rolling this out to industry through an education webinar, easy-to-follow checklist and translated resources. Ongoing efforts are being made worldwide and in Australia to further improve the ability to test for silica dust at lower levels, such as 0.02 milligrams per cubic metre. Safe Work Australia is coordinating this work in consultation with its members. In addition to this, the New South Wales Test Safe Lab routinely reports down to 0.05 milligrams silica levels for 8-hour shift samples. TestSafe has noted in its research that further lowering of the level to below this, although possible, currently presents both technical and commercial challenges due to measurability issues, which is echoed by the Australian Institute of Occupational Hygienists and the National Association of Testing Authorities, that is NATA. However, TestSafe has expressed confidence that further research offers potential pathways for increased sensitivity and further lowering of the exposure standard in time. The Centre for Work Health and Safety has engaged Trolex NOM Australia to develop a respirable crystalline silica sensor, which can provide real-time feedback to workers at risk of exposure. This technology has been independently tested now in both laboratory and workplace environments to be able to measure the workplace exposure standard of 0.05. The device is planned to be commercially available in June this year, with rebates from Trolex to support their purchases and a wearable device anticipated to be market ready by 2023. Safe Work New South Wales continues to conduct educational, compliance and enforcement activities to ensure that PCBUs at engineered stone fabrication sites are fulfilling their work health and safety duties, including air monitoring where appropriate. In total, more than 6,704 silica-related business interactions have been completed in New South Wales, with 957 of these being manufactured stone inspector visits and 718 inspector visits in other industries, including construction and tunnelling, since the start of hazardous chemicals strategy in 2017. Safe Work New South Wales has also reviewed the 214 silicosis cases across all industries from 2017 to 21, with 16 accepted for full investigation where the exposure could be linked or attributed to a workplace, 7 of which of these have since been discontinued, closed, 7 are still open, with further evidence being gathered, and 2 have been filed in court for charges to be considered. 135 of the 214 cases over this period relate to the manufactured stone industry. Safe Work has also overseen the delivery of an industry-specific engineered stone rebate worth $1,000 for businesses to purchase safety items to protect against silica exposure. An additional $1,000 is also available under our small business rebate as well. This addresses issues such as improving ventilation, exhaust and extraction systems, water-fed and dust capture tools, powered air purifying masks, or mask testing kits. As of the December 21, 2,008 rebates have been granted, resulting in over $279,807 being invested by business on dust controls. In June 2021, the National Dust Diseases Task Force final report was released. The Department of Premier and Cabinet is coordinating New South Wales' contribution to the Australian all-of-government response. Safe Work New South Wales has provided its contribution to DPC. It is important that there is a national approach guiding the relevant agencies to continue working together and ensuring consistency among jurisdictions. In conclusion, our work is ongoing and remains a key priority, both now and into the future. It is a joint effort, however, that relies on the New South Wales whole-of-government approach between the relevant agencies, such as Safe Work New South Wales, iCare, CIRA and New South Wales Health, to ensure workers are protected from dust diseases such as silicosis. Once again, thank you for providing me with the opportunity to present on the committee to the committee today.
Thank you very much, Mr. Williams. Ms. McCool, could I invite you to make an opening statement if you...
Tony's on behalf of both of us. Thank you.
Thank you. In that case, I'll turn to the committee for questions, and I'll start with Mr. Diadam.
Chair, and welcome to this inquiry. Thank you for your attendance today. Look, earlier in the proceedings today, one of the witnesses was quite frank, and they said, in reference to safe work, the policeman is not doing their job. We also heard evidence from two individuals who've directly affected by exposure. One had 30 years in the industry, had seen safe work once at a work site. The other, I think 20 years odd experience twice in their working life, seen as a safe work inspector. How can we have confidence that you are able to keep on top of the compliance obligations that safe work has in relation to this industry, given that type of evidence?
Well, firstly, as I said, anyone that is sick, injured or killed as a result of their work is important to us, and it's why, as I said, this strategy has a number of aspects that we've been closing the gap on for a number of years now. But in terms of what we have done in terms of compliance and just that aspect, we have visited the manufactured stone sites multiple times. We call it round 1 and round 2, but within those rounds, follow-ups are done any time a notice is issued, so it would trigger a second visit. So when you're looking at round 2, as at the 31st of December, with 255 sites, the notices have gone down from the first round from 699 down to 274, and most of those notices relate to things that are considered minor in nature. We've only had 2 instances of dry cutting. We're seeing significant investment in CNC machines where essentially the workers are removed from the cutting. It's digitised and cut more or less in a booth with water. The sites are significantly cleaner. Workers and PCBUs have significantly better knowledge. We're seeing hazardous chemical registers, safety data sheets, RPE not only worn but training on it and fit tested. We're seeing workers in a regular program of having their health screened. So that represents in round 2, after looking at these sites for a number of years now, an 84% reduction in the number of notices and a 61% overall improvement in the industry in heading in the direction that we intend to continue with.
Cool. So on the evidence that you've just given, those are sites, the 274 that have received notices on a second visit. So, I mean, these are sites that have already, they've already been visited, they're well aware of their obligations, they're repeat offenders. What did you do? Well, like, how was that, those incidents treated by Safe Work? Was there more stringent enforcement, or was it just a repeat of the improvement notices that you'd already issued?
No, there's very, very little repeat of the same behaviour, and very rarely, in terms of, even when we did the first round, only 60 sites didn't get a notice at all. Typically, we will find something, and it could be a forklift, it could be not having a safety data sheet, it could be things that, in terms of the core of the issue, around dry cutting and not wearing protection, that is significantly lower, or we're finding, as I said, we're not issuing any notices in that space, or it could be that the mask has been provided, it hasn't been fit tested. So you're looking at things are in place but still needs to be fit tested, or you're looking at there's some new workers in the workplace, they haven't been screened yet, so we're issuing notices for those workers to be screened as well. So things like even general housekeeping, if we do see things around, notices could be issued around that nature. But in terms of prohibition notices, we've only issued 6 in the second round, showing that, as I said, we're not prohibiting practices. The issues that we're finding are generally what we call maintenance issues.
I mean, obviously you've had a concerted effort over the last couple of years in terms of site visits. That's not sustainable in the long term, is it? Given the resourcing of Safe Work, you're not going to be able to do that level of intensive site visitation going forward. How are you going to sustain the compliance culture that needs to be embedded in these in this industry given its volatility, it's made up of a lot of small businesses. I expect that there's quite a bit of churn in terms of the industry. How are you going to sustain it in the long term?
Well, I think it's been demonstrated by round 1 and then round 2 seeing the significant improvement. So by round 3, we should see even further improvement where it is just a spot check. The industry has responded. The industry is improving, but that's we're held together by doing an annual report, which, as you know, is now within the Work Health and Safety Act that we must produce an annual report. So we're tied to this issue in continuing on in this space, but in terms to keep us accountable, but in terms of the industry improvement and the inspectors we have, it's proportionate, and in terms of we're starting to see, as I said, the checks are not taking as long. We can do more within the time period, and as I said, we're starting to look at, as I said, we've already got that 61% improvement and closing the gap.
And sorry, Mr. Deadham, if I can also add, we're seeing a lot of business investing heavily in technology. So, you know, that isolates workers from the risk. Once that happens, you know, we'll see a reduced need to undertake compliance in those workplaces. We'll still do compliance, but the regularity and the ongoing need within those workplaces is reduced. We are try to do our work on a risk-based approach. So if we're confident that, you know, visit after visit in a workplace identifies that they've invested in the technology, the risk is removed from the worker, we're not seeing any issues in terms of exposures, we would have our response would be proportionate to the risk we are seeing in those workplaces. So we do expect, you're right, we wouldn't want to maintain the levels we're maintaining now forever, but the technology we're seeing being applied in workplaces will mean that can be less.
Your emphasis in terms of compliance is very much focused on the factory environment, the fabricators. We've heard evidence today, and I asked a question about this at estimates, about an incident of uncontrolled dry cutting occurring in a suburban context. I mean, you don't have the capacity to be able to enforce the ban, do you, in those kind of circumstances? So
our strategy covers all industries, whether it's tunnelling, whether it's construction, cutting bricks, concrete, and manufactured stone. When we're checking the fabrication workshops, we look at all their what we'd call SOPs, or standard operating procedures, or their safe work method statements, including right through to the installation. And wherever we issue notices or compliance, it applies to the whole end-to-end chain. So in terms of being anywhere at any time and being able to see it actually happening on site, that is, as I said, a bit more of a challenge in that there's not a fixed premises, but that's the same with all natures of work. We have the ability to respond. We have looked up at that incident that you raised at budget estimates. There was an inspector's visit at both the homeowner's place of residence as well as the workshop. So we do respond to those and we do encourage people to report anything. So both us doing our spot checks plus anyone informing us are the two areas, as I said, which is the nature of any work done where it's not a fixed premises.
That's right, and the committee may be interested to know that of the 1,675 workplace visits we've done to date, 957 have been in the actual manufactured stone workshops in the workplaces, but we've got 720 that were done in other workplaces, so on construction sites, tunnels, quarries, you name it. So we've done 720 in those workplaces as well. And the way we make that sustainable, Mr. Deadham, is that we incorporate that into our business as usual. So if our inspectors are out on a construction site or in a tunnel in an infrastructure workplace, not only will they do what they're there to do, they will, as a matter of process, to the verifications to check for silica dust exposure, plus other programs we might have on foot at that time. So we try and use our inspectorate economically and maximise the bang for buck whilst they're on site.
There was evidence earlier today about I suppose there's a very strong emphasis in your compliance strategy on educating employers. But we heard evidence today that actually education's not the problem. The employers know the dangers of this substance, and there are cowboys in the industry that are going to continue to flout safety regulations. how are you going to drive those cowboys out of the industry?
Yeah, so we do agree. Education's just one element, but our strategy has included 4. So it's education, it's compliance, it's legislation, and the changes that Mr. Williams spoke about in the opening statement, as well as research. So that real-time detector where an alarm goes off if the exposure standard's being exceeded. So we're looking at not only innovation and protecting workers through that way, and that's been research that we have commissioned as a regulator, as well as the compliance approach, and as I said, the improvements that we're seeing with those visits. So education, but you can't have compliance without education. Those two generally work hand in hand, but we agree education is not the trick. There's 4 elements, and our strategy is continued to deliver on those 4 components of the strategy.
I asked in estimates about HSRs, and you've returned data in relation to your visits, updated data, I think, a couple of days ago. The number of HSRs in these sites is paltry. Why isn't your compliance strategy more placing more reliance on having effective consultative and monitoring strategies in place, embedded in the workplace through the system that's available under the Act, the HSRs? Why aren't you driving businesses or encouraging businesses to put HSRs in place so that there are those ongoing eyes and ears able to keep an eye on the safety culture in a business and be able to provide that direct enforcement that might be necessary in terms of improving safety cultures?
Mr. Diadam, just apologies. For the benefit of Hansard, I don't know if we've mentioned HSRs is...
Sorry, a health and safety representative.
So in terms of consultation is a core part or the fundamentals of the work health and safety legislation. It's always encouraged. However, we can't enforce to have a HSR, and most of these business are 0 to 5 workers. So a HSR or a worker within the workplace has to request to become one and then sent for training to receive their powers, which includes all the things that a HSR can do. But in doing that, as I said, a workplace may have other agreed arrangements that's equally allowable under the laws, or as I said, if it's only the person running the business and the worker, consultation obviously would be happening day in, day out. What we would do though, if we saw that new practices were being introduced or there wasn't any evidence of conversations going on, and we can easily tell the culture of a workplace when we enter, we would, as I said, we can issue notices around that the consultation is not sufficient in relation to the workplace, and have issue notices for improvement in that space. The one thing we can't do though is insist or mandate it has to be a HSR. That's a process where the worker nominates.
Is that a limitation that perhaps it would be of assistance if the legislation was amended? Like, would that be advantageous to be able to, as a result of issuing an improvement notice saying, look, you've got to put a HSR structure in place?
Obviously, the laws are reviewed at any time, and this is a national law, so this is around the country that this is how consultation operates. Certainly, we could put it into a review of the national laws, but unless, as I said, we're not seeing any evidence that there isn't consultation for us in this particular industry. Obviously, a desire to have a HSR in every workplace in the manufactured stone industry is important, but in terms of, we're not seeing, as I said, massive amounts of notices or issues in relation to the workers not being consulted. If there was, then obviously we could certainly look at that, but in any review of laws, it's certainly something that we could consider.
If you had ubiquitous HSRs, you'd be able to have targeted training, wouldn't you? You'd be able to get them in, or you'd be able to deliver specific training packages to the HSRs to assist them in identifying the kind of risks that are associated with poor practices in handling manufactured stone. Is that correct?
Well, we can do that now with any worker. We have ran a symposium event. We do trade information nights. We have various, if you look at our catalogue of the stakeholder engagement we do education with the suppliers. So education is happening all the time, and we do that in multiple different ways. We also have rebates, as I said, to incentivise purchasing better products. So we use a number of tools to lift education. HSRs is just one aspect that that could be used, but there's plenty of others that we capitalise on in terms of lifting education in that sector.
Got one further question. I just wanted to ask about the code of practice that's been recently released. Can you advise what consultation was undertaken by Safe Work in terms of the development of this code of practice? I know it's a model code of practice that you've picked up from Safe Work Australia, but I mean, this is still something that you've done at a New South Wales level. Isn't there an onus on you to engage in some form of consultation about whether this is appropriate for a New South Wales context?
So Safe Work Australia issued a national consultation process. So we alerted obviously all our stakeholders and businesses that that would be relevant to. But in terms of the process, it was managed by Safe Work Australia. So any comments, particularly around its practicalities, the detail in it, went back into a national review process. So any New South Wales stakeholder, including ourselves, were encouraged to make comment on the content of that document. The content of that document, now that it's a code of practice, is enforceable. So sites need to be at the same or equal value of that code, and where it's not demonstrated, we can issue notices. So if anything, as I said, that has become an enforcement code in, I guess, general terms.
Thank you, Mr. Diadam. Just before I pass to some other members, I'm just going to flag that I've had a message from Mr. Shoebridge. He is just occupied at the moment, but will be returning around 2 o'clock. Noting that we've got the witnesses until 2:15, it's my intention that I'll reserve a little bit of time at the end for when Mr. Shoebridge arrives, because he's indicated that he's got some questions. So what I will try and do between now and 2 o'clock is to make sure that the rest of the committee has the opportunity to ask their questions. Then I'll pass to Mr. Shoebridge on his arrival. If everyone is accepting of that, then that's how I will plan the next the rest of this session. Mr. Roberts, you have the call.
Thank you, Chair. I'll direct my question to you, Ms. McCool, I think, although Mr. Williams, you feel free to answer. I want to direct your attention specifically to the manufactured stone industry. I know we're aware that silicosis happens in quarrying and tunnelling, but I want to direct your attention specifically to that. We're aware that wet cutting and ventilation in factory sites where the fabrication takes place is in place and is a good thing. Notwithstanding that, though, I want to know how many penalty notices or prohibition notices that you may have issued for dry cutting on actual work sites. Remove yourself from the factory setting, take yourself to a job site. Over the years, how many notices have you issued for that, for dry cutting there?
So the information I have, since the dry cutting ban or the on-the-spots fines came through on the 1st of July 2020, we've issued 2 of those prohibitions or on-the-spot fines.
How much were they for?
The fine is $3,600.
That's the full fine?
Yes.
That's the fine?
Yes.
Right.
As prescribed in the legislation. In relation to where those 2 were, I would need to take that on notice as to whether they were on stone sites or installation sites.
I'd like to know that, so can you take that on notice for us? So there's only been 2?
Evidence of 2 being detected where we've evidenced that, including, as I said...
How do you detect it?
Well, there's a number of ways. If we walk into, say, we'll start with a work site. If we see a broom, we see dust on the floor.
We're not talking about brooms. We're talking about at the actual work site. It's at a, not in the factory.
Yep.
At an actual construction site.
Essentially, we're looking at the setup.
Apologies. I note that when there's one member talking, it makes it difficult for Hansard if we are talking over the top of each other. So I might just allow Ms. McCool to finish her answer before you ask a supplementary question, if that's okay.
I accept your ruling, Chair.
Thank you. So we would look at the practice. So how the bench is set up, is there water-fed tools, is there vacuum-related tools, is there a dust accumulation? We know very clearly if dry cutting is happening when we enter the site, whether that's, as I said, on-site in an installation, it's very obvious. And if the correct tools aren't, so if there's only a grinder and there's no water-fed tool or vacuum-related tool, straight away, that's dry cutting. It's very clear to us.
How do you find these sites to inspect?
Yeah, well, I was just going to go to that point. So that unfolds in a number of ways. So each year our construction teams, and we have a dedicated construction team for our metropolitan area, and we also have a dedicated construction directorate for our regional areas. A lot of these matters are identified just through our routine day-to-day work, visits to construction sites, of which we do thousands each year. At those sites, often they will have specific tasks to do, whether it's a set a program verification project we might have on foot at the time. And when they enter that site, not only do they do that, but they may also make observations about other issues. Some of them can be just drive-bys. So it could be what we call a high-risk work observation. So they're literally driving by in their vehicle between sites, and they'll see something, they'll pull over and stop. It could be someone on a roof or cutting, whatever the case may be. Or from time to time, we have people members of the public, report those matters to us. As you would appreciate, we now have our Speak Up app, which we heavily promote to the community. So if they do see somebody, dry cutting, a manufactured stone bench, we would love nothing more than for a member of the public, without putting themselves at risk, to take an image of that, send that to us, and we can respond to that, give that a very high priority and respond to that. Now, the nature of the work, as I think we're all aware, is quite transient. So often the people installing these, doing the work with the benches, can be there for a very short time. They might literally be on the site for half an hour to do the installation, and then they're gone. So it can be difficult to identify, so we do heavily rely on other members of the industry, on our inspectors just getting around, and on the general public. So we identify them in a myriad of ways. So I hope that answers the question you posed.
All I have for the moment. Thanks, Chair.
Thank you. I'll pass now to Mr. Amato.
Thank you. Thank you both for being here today, and nice seeing you both again. Earlier on, you mentioned about a lot of companies are starting to install, I think it's CNC machines, and they're obviously in a isolated room, is it a wet room?
Yeah, it's generally motorised where I guess all the figures are put into the computer, I guess is the best way to describe it.
Is outside usually away from?
It could be in the workshop, but it is in an enclosed space away from the workers. It's cut underwater, and it's obviously more accurate as well in the cutting because it's to the measurements put into the machine. We're seeing a big uptake of those machines in particular, but also, as I said, in general, when we're attending these workplaces, quite clean work sites, as I said, safety data sheets are visible, hazardous chemical registers, RPE that's been fitted and tested, training's been provided. So in addition to the machinery, the other practices are coming, as I said, 61% towards standard and continuing to go that way. But it's significantly different environment to the first round.
So how's the clean-up process? How's that operated?
So there's two parts to that, and I'm not trying to avoid the second part of the question, but the first part is around it's bagged, the slurry is collected, and including, as I said, any sort of dry material, which is vacuumed. Once that's disposed of, I heard the questioning earlier today about what happens when it gets to, say, the tip or things like that. That actually falls under the responsibility of the EPA, so I can't answer those questions for you.
Okay. No, thank you for that. And when it comes to the installation, how's that been regulated? Obviously, as and Mr. Dowden went, the worker comes in, the installer comes in, does a job, and off they go. Obviously, there'll be dust particles and so forth. So I can see that's very difficult to regulate, but once they're in place, what sort of guidelines are there for the actual installer?
Yeah, so when we're inspecting the fabrication site, knowing that 85% of the industry is controlled by that fabrication site. So the people doing the installation, 85% are connected to those sites. There are ones, but at the end of the day, they've got to come to those sites to get the stone. So there's I guess a connection that we're very familiar with. When we're inspecting those workshops, we're looking at all procedures right from end to end. So what is their controls in place for their installations. And at any time, as I said, we can say, well, we need to see some installations occurring. So it doesn't matter where in the life cycle of it being cut to size through to installation, with 85% plus being controlled by those workshops, and we can review everything, and any notice issues applies to all steps of the process.
And that also includes any subcontractors they may have?
That's correct. So the way the laws are written, it's a person conducting a business or undertaking. It doesn't matter if they're a subby. It doesn't matter if, they're subcontracting out a big proportion. It doesn't matter if they're a full-time employee. It doesn't matter if they're a visitor or work experience. Everything is controlled under the laws by that person undertaking the business. So it doesn't matter where an issue happens in the chain. That principal person is responsible for the matter.
Thank you. And just the last question before I pass it on. Earlier witness mentioned there's been regulations in Europe for this industry since 2010. Why was it taking us so long to start doing something about it?
So there are regulations in place. So you heard about the Code of Practice, which, as I said, is an enforced code or called up in the legislation. There is now in the legislation a ban on uncontrolled dry cutting. The exposure standard's been halved from 1.0 to 0.05. There's actually fines for failure to report a silicosis case, and it's now compulsory for all diagnoses to be reported to New South Wales Health and then handed over to Safe Work to investigate. So that, in terms of the regulatory landscape, they're the things that are in place just in relation to manufactured stone, with, as I said, that code of practice describing everything from the way you start the job to finishing the job, now enforceable in that document in terms of you need to meet that by equal or same value. So that completely describes what's right and wrong in terms of operating in this industry.
Would Fair Work have known about regulations that were in Europe used beforehand?
I couldn't specifically comment on, so what, you did mention a country?
So if European countries, if they already had regulations in place and they're already aware that there was serious issues with a particular product and obviously diseases caused to the workers, how come it would take us so long for us to go, hang on a minute, we have a problem? Is there a way how our departments here have overview of what's happening in other countries, like in the US, the UK, in Europe, to keep up to date with perhaps what's happening over there? So
of course we do look at that. I can comment from 2015 when I commenced in the role that they are the things that led us to developing this strategy, also way ahead of most of the other jurisdictions in Australia as well, including the 4 components, which was legislation, research and education. So from that point in time, the cases weren't coming through the data, in that people might have been presenting to, particularly in the health system, and we didn't know about it. It wasn't looped in. That's now changed. We get diagnoses from anywhere a person or any health related to silicosis comes to us in any industry, not just manufactured stone. So from that 2015, 2016, we did a research project which did include what's happening overseas, and from that point on, that's when the strategy, which we've been continuing with since then. So that's where I can comment on from about 2015.
Thank you very much. I'll pass on to one of my other colleagues.
Thank you. I'll go to Mr Donnelly, then Mr Budgie.
Thank you both for coming along this afternoon. Mr Williams, just referring to a couple of aspects in your opening statement. Can I take you to page 4, please, if I could? And specifically under the heading National Dust Diseases Task Force, part of that page. And it says there, and I'll just read it because it's a short paragraph. In June 2021, the National Dust Diseases Task Force Fly Report was released. The Department of Premier and Cabinet, DPC, is coordinating New South Wales' contribution to the Australian all-of-government response. Suffolk New South Wales has provided its contribution to DPC. It's important that there is a national approach guiding the relevant agencies to continue working together and ensuring consistency among jurisdictions. Now, can I ask you, in terms of safe work, the centre says Safe Work NSW has provided its contribution to DPC. Have you been involved in the development of that contribution?
Mr Donnelly, I might refer that to Ms McCool, who's been more involved with that process.
Sure.
Yeah, so in terms of the comments, we went through all the recommendations and provided comment on the various things. Some of the things that probably stand out is that some of the recommendations recommend regulatory impact assessment to be done on some of those areas. So obviously the recommendation isn't, I guess, complete. It's that something will be considered as a result of, say, a regulatory impact statement. So those things there are welcome to make sure that decisions, when they're made, are the right decisions and are actually what will solve the problem.
I particularly want to get to the point of licensing with respect to those entities that are in the industry of manufactured stone. I mean, we're aware of the history of the production of a report by this committee and its recommendation number 8, which was not endorsed by the government in terms of the establishment of that. And what's I'm just finding a bit challenging is this, that it seems that New South Wales, which is 1/3 of the Commonwealth in terms of its size and the economy of the Commonwealth, that it's got its position on this matter of licensing hitched to the national process and the national outcome, and is essentially moving with what happens nationally. That's, as I understand what's said there. Is that correct? That New South Wales is, in effect, hitched its wagon to the national process and the national timetable. Is that correct?
So to do any kind of licensing, as you know, with the IPART processes, licensing is considered a last resort option that has to have a RIS or a regulatory impact assessment. That assessment will determine across the country if it's the right solution. So things that will be assessed is regulatory and non-regulatory options, everything that's in the marketplace at the moment, including codes of practice.
I don't wish to cut you off, but it was a very clear question, and that was that in a sense, New South Wales's position as the state of New South Wales, in terms of a licensing regime, has hitched its wagon to what is the development of a position at the national level. Is that correct?
Ms McCool, could I just confirm, you were providing some context before coming to an answer, is that correct?
Yes.
That's the way that I interpreted it.
In terms of, as I said, for us to consider licensing as an option, we have to do a regulatory impact statement or a regulatory impact assessment. So it's not necessarily attached to the national in that being completed, but it's going to inform nationally. And as Mr Williams talked about earlier, this is a national problem that needs to be resolved nationally so that there isn't any deviation, particularly with workers that move around the states. So for us, as I said, having the right decision made, the right solution, so if licensing is the right solution that comes out in that assessment, that will be considered by obviously the government.
Well, let me put it in another way then. That we have a situation whereby you're aware that at least one other jurisdiction has got a licensing system in place. Perhaps two, is it Queensland? Does Queensland got one? Certainly Victoria has.
Yeah, Victoria definitely.
Definitely has. So let's take Victoria, which is the second largest state in the Commonwealth in terms of size and population and its contribution to the economy. So the second largest state has a licensing system. You're aware of that, aren't you?
Yes, so it commenced in...
Sorry, I'm just moving through some questions, so you're aware of that. So it isn't the case, is it, that in fact a state has to wait for a national position to be established on an occupational health and safety matter before it moves on it. That is the case, isn't it? Doesn't have to wait,
Victoria actually isn't under the national legislation. So for us, under national legislation, we have to first take the issue to the national table, and then if unsuccessful, we can more or less go it alone. That process is in place, that it's on the national table being considered. In terms of Victoria, that started in November, that was the beginning of the start in that there's a 12 months transitional arrangement, which is November this year. Hopefully that impact assessment's there to either confirm or not confirm whether that's the way to go, and if it is the way to go, then the systems will follow suit in licensing. But when you look at the licensing regime for Victoria and you look at the requirements of what they need to do, they're things that we're already doing, checking operating procedures, and more or less what's defined in the code of practice is what essentially is their regime. So you've got a code of practice, you've got, as I said, the requirements that are outlined in terms of enforceability, and then you've got the assessment going on in terms of, from a national approach, should licensing be the option that should be delivered.
Isn't the difference there that with a licensing regime, the manufacturers, those who are handling manufactured stone, they have to be proactive, whereas with the regime that's in New South Wales, they just wait for the regulator?
They still need to be proactive. The legislation places obligations on all of those PCBUs to.
But I mean, if they wait, what do they get? What's going to happen to them? You're going to turn up and you're going to issue them with an improvement notice, aren't you?
Mr. Diadam, I'm just going to make the same point I did to Mr. Roberts earlier, which is when the witnesses are providing an answer, I'd ask you to just wait until they've completed their answer. That way it's better for Hansard and also those viewing, and it allows procedural fairness for everybody involved. Mr. Williams, you've got the call.
Thank you. And look, I would say that New South Wales as such isn't opposed to any licensing scheme. That will be a decision for government, but there is a process, as Ms. McCullough has identified, that needs to be processed. I would make the point that in terms of industry size, you know, this industry, that is the manufactured stone manufacturing industry, is fairly niche. Like, you know, 255 odd sites is in the scheme of things, when you compare it to other industry sectors, fairly small. So we do know very accurately where they are, what they're doing, and we have a high compliance focus now on those workplaces. So, and the turnover in that industry is fairly slow, as we've seen in the last few years. So it isn't a huge industry to necessarily require such a scheme, or that it would deliver great benefits as compared to much larger industry sectors where it is more problematic to regulate.
Mr. Adam, have you got further questions on that point, or can I pass back to Mr. Donnelly before passing back to Mr. Buddy?
On that particular point.
I've got more, but I think there's time to go around, so Mr. President.
Okay, so I'll pass to Mr. Buttigieg. You've got the call.
Just tease our way back into that.
Mr. Buttigieg,
sorry, Chair. We might just tease our way back into that the question of licensing through another route, if it's okay. I'll just pick up on one of Mr. Williams's statements there about 255 sites. So just to be clear, this is sites where it's purely manufacturing of engineered stone, correct?
Correct.
So my colleague's point earlier, Rod Roberts, is that potentially, if we're talking about the incidence of exposure, including kitchens and people's houses and whatnot, this is do we have any handle on the sort of flux of those sites over time? Has there been any investigation or studies into what that might be at any one time? Because the actual problem, properly defined, is on Globo, isn't it?
Yeah, look, and I'm happy for Ms McCall to correct me on this, but I understand something around the 85% of the people installing are actually linked to those workplaces. So I don't know if you wanted to expand on that.
Yeah, so that's correct. So whether or not they're a direct employee or subcontractor to, 85% are connected to those workshops. But also as a result of our site visits over the first and second round, 19 have since closed. So we're very clear who is in the market and who's not. And obviously those that have closed have not been able to meet our requirements.
But the 85% ratio you're suggesting, that sort of superficially implies that you might have, 300 sites on Globo. But that's not the case, is it? Because you could have one manufacturer doing 100 kitchens in a week. So you can see the exponential nature of this, can't you? So isn't the problem to try and get a handle on those sites on Globo? And my question was quite specific. Do you have any study or research into what that might be at any one point in time?
So I'd probably just slightly change to a different angle to probably clarify, and if I haven't answered it, please ask me to explain again. But we follow the stone. We know that there's only a certain number of importers, and then that goes to a factory, and then it has to be cut to size. So in terms of, we've got all of that information, and then from there, as I said, with 85% from that point still being connected to that site. So yes, there is a gap of 15%, but that 15% is where we're talking to the sites, where's the rest of the stone going?
But of that 85%, and thank you for that answer, so let's just focus on the 85% that we know. You can actually go to the manufacturer and go, can you tell me where your blokes are working today, because we want to go out and have a look.
Yes, we can serve a Section 155 notice, and we have done so. If we feel that it's within our powers and need to do that, so we can issue a notice to anyone in that life cycle for information that we need, particularly if we believe there's a contravention of work health and safety, or it's for the purposes of protecting workers.
Can I ask how many times that particular section has been utilised in the last couple of years?
Sure, I'd need to take that on notice, but it has been utilised particularly with all the suppliers.
Okay.
Sorry, you just say, in your answer, you said you can issue the notice if you believe that there's a contravention occurring. So there has to be some prior information provided to Safe Work, doesn't there?
Not necessarily. If it's for the reason to protect workers, we can serve Section 155s, which is about information, any time for the purposes of our inspection programs. So if it's lawful and it's information we need to be a regulator and to enforce compliance, we can issue a Section 155. Obviously that can be appealed if they believe that information isn't lawful. So that's, but we can issue a notice if we believe there's information that we need.
And is that now a routine process for this industry? Are you routinely issuing those notices? So that
no, probably more so, as I said, in terms of establishing a lot of, I guess, the industry trends. They were issued in the early stages, but generally the industry has been very forthcoming with information, very cooperative in our visits, and as I said, when we're securing compliance through those channels.
Wouldn't it be better if the onus rested with the industry just to supply the information rather than forcing the regulator to constantly be proactively trying to extract the information?
Of course. Industry, if they're willing to provide us information, of course, but where we need it and it's not been...
if you had a licensing system in place, couldn't you?
Mr.
Then that would be required to provide it.
Mr. Down, apologies. I'd just ask again if we could allow one answer to finish before we talk over the top. But I'll let you ask your question.
Wouldn't a licensing regime then provide you with that information in a routine way?
As I said, I think we've explained the number of regulatory options and a number of regulatory powers that we have available. Obviously, a one-solution approach, if it is licensing, it's licensing. But in terms of, as I said, I don't feel that we're impeded in our work as a regulator in what we've been doing in terms of improvement in compliance. The powers we have at the moment, as I said, are securing the compliance as intended. Obviously, if the decision of the government is to introduce things like that, then that's the next steps. But in terms of, as I said, we have powers, as I said, to be able to move that industry to a 61% improvement with what we have at the moment. That code of practice, as I said, has been very welcomed in terms of there's no grey. It's either you comply this way in terms of the way you work or you're not complying. Obviously, different sites might have had different ways of doing things. That code now settles that in that this is the way that you are to work safely in the manufactured stone industry.
And can I just say that I know the question was asked previously about how we identify, those work practices that are putting workers at risk, and we do that in a myriad of ways, as I said before. But should we start by way of example? Should we start to receive, intelligence from the community or from other businesses that we have, installers, dry cutting, haphazardly on work sites, and we started to see a link back to one supplier that is the sort of circumstance where we may then issue a Section 1552 that installer to understand where they're installing. We'll start to visit them. So they'll then get a much stronger and more focused regulatory response to others. So it can often be very driven, and we see that not only in this sector but other related sectors where we use that power, where we start to form the view that we've got a PCBU here that just isn't doing the right thing. And the statement was also made before about wanting to get the cowboys out of the industry. We also want the cowboys out of the industry. And one thing we do call out, and we call it out in our roadmap strategy document, is that we want to play a role in control in creating that level playing field. So we don't want installers, and suppliers undercutting each other by making their workers take risks.
I mean, in estimates you said, on the issue of trying to shut down the cowboys, you said we don't shut down businesses or sites, we shut down processes.
Yes.
I mean, under the current regime, if you've got a non-complying recalcitrant employer, you'll shut down processes, but you can't actually deal with the core problem. Whereas if you have a licensing scheme, don't you surely, then you can cancel the licence, you can take them out. They cease to be able to operate as a business. Isn't that a much stronger regulatory approach?
But if I can use a practical example, if we do identify people dry cutting, to cut power points or whatever it is on a construction site, and we issue a prohibition notice to stop that, it effectively stops that business. Now, that notice might not be to shut down the business as such, using those words, but it will stop that task until such time as that we're satisfied that they've improved their processes to the point where the inspector has formed the view that they can recommence that. So it effectively does stop their installing. So it does a similar thing.
I think my colleague's point is that you might have one dry cutting process in one kitchen or site that occurs where you've issued a prohibition which stops that particular activity, but it doesn't stop the business from engaging in other work. So a licensing system would do that, because effectively if you lose your licence, you lose your ability to operate. Let's go back there in a little while. I just want to explore some of the evidence that's been put on in response to my colleagues' questions. So I know, Ms Cool, you said you'd taken on notice, but I just want to ask you a follow-up on the Section 155. Are we aware that any have been issued whatsoever?
Oh, yes, and there have been some recent ones as well, but we can definitely pull them out for you and explain who they were issued to and the reasons for.
Right. I just want to step, so we've got a clear understanding of the hierarchy, if you like, of the punitive approach. So the first step is what, an improvement notice? So if I were engaged in dry cutting, uncontrolled dry cutting, would the first step be an improvement notice, or could I go straight to a fine?
No, it's always been a prohibited practice. So even before the on-the-spot fines, a prohibition would be issued, which stops the work. The other thing, a prohibition is never lifted. So you could change your practices so you're not dry cutting, but you can never go back to it. And if you do, there's actually, to breach a prohibition is $100,000 penalty. So again, it becomes in terms of it's prohibited and banned, and then particularly if you breach the prohibition. If you breach the on-the-spot fine, it doesn't have the same. So normally, as I said, is we can issue prohibition and the on-the-spot, but the prohibition actually prohibits the behaviour and makes it very clear. And also, if there's a repeat offence of that prohibition, that can result in a $100,000 penalty.
So sorry, the prohibition is on the act of dry cutting. So if you continue that process, wet cutting, it's okay.
So without getting into too much technical information, you need to be cutting the stone, what we call controlled cutting, which is either with water or a vacuum. So it's controlled at the source to basically capture that dust. If there's no evidence of those things in place, then essentially it's a prohibited practice.
Yes, and the prohibition, though, to be clear, is on the original uncontrolled cutting, not... If I subsequently right my wrongs and start vacuuming or wet cutting, it's okay for me to continue to do that process.
That's correct, because you're now compliant with.
Okay. And so, so beyond that, when does the fine kick in? Then what makes you not give a fine or give a fine if you've been issued a prohibition notice?
So essentially, as I said, if it's a contravention and it's clear breach, obviously the inspector forms their opinion and they can issue that straight away. So there's nothing in terms of any, and particularly the on the spot, as I said, that's 3,600. But the prohibition, as I said, is generally issued as well, because then you've got the two angles of compliance. So with or without that on the spot fine being introduced, we were already prohibiting the behaviour, and we can prohibit that in any industry as well.
But you could, in theory, issue the 3,600 fine without the prohibition, could you?
You could, but it still, as I said, is a contravention if it's a repeat breach.
Okay. And that 3,600, just to be clear, that is directed to individuals and or ABNs or whoever the person is or the entity is doing it?
It's generally issued to the person conducting the business or undertaking, regardless of who did it. And then obviously, so it's not necessarily issued to the person doing it specifically, unless, of course, they own the business. So it's issued to the business.
Mark Buttigieg working for Caesarstone, and I do this on 4 occasions, Caesarstone could get 4 lots of 3,600.
Which could then result in further action, so that could end up in a prosecution. So essentially, as you know, in our hierarchy of compliance, as I said, repeat offences, we escalate.
And those two fines, two, I think, in the space of, where are we, 1st of July 2020, so almost 2 years, 2 fines in 2 years, were they as a result of people proactively reporting, or was it as a result of Safe Work going out and checking?
I'd need to take that on notice with the other question. We can pull apart what they were for and who they were to, and whether it was proactive or reactive.
Okay. I just want to explore this. I mean, the flavour of the submission from Safe Work is that there's a number of, and I grant that there seems to be quite a bit of activity in this area, education, webinars. We've heard about the site visits. So it's, I mean, what I would characterise in my interpretation as a ameliorative approach, a reactive approach, if you like. But going back to my colleague, Mr. Donnelly's questioning around the licensing regime, do Safe Work in principle support the concept of a licensing regime a la Victoria, notwithstanding your caveats about the impact, the regulatory impact statement and the national approach? Let's assume that came back okay. Do you support a licensing regime?
On that assessment, if the assessment had that it is the right regulatory tool, of course we would support it, but it's a decision of the government.
Okay, and just to clarify again that line of questioning from my colleague, the point I think Mr. Donnelly was making is that New South Wales has taken a conscious decision to go under the umbrella of that national approach with the regulatory impact statements and all the rest of it. But clearly there's an alternative path which the Victorian jurisdiction's taken and gone out on their own, as I think to use your words. Do you have a view on whether or not that would be appropriate in New South Wales?
Well, as I said, for us, it has to go to the national table, and that's exactly where it is right now. So
I'm sorry, Chair. Just to clarify, I mean, it doesn't have to, does it? Clearly.
No, sorry. Ms McCool was answering.
Yes, sorry.
When the witness is answering, we allow them to finish before we start again. Ms McCool, you've got the call.
Thank you. In terms of Victoria, as I've mentioned before, are not under the national legislation, so they're not bound by the requirements as New South Wales are. For New South Wales, we have to take any issue of change because we're tweaking what the national law says to the national table. It's only when the nationals either don't agree with us or we don't get majority vote that we can then go it alone. But so the process it's at now, it's at that national table. So essentially, if it's positive or negative, as I said, if it is negative, then New South Wales has the decision if they want to go it alone. But at the moment, we don't have that ability to do so until the national decision is known.
New South Wales bring it to the national table, or which jurisdiction actually raised it in the national?
It was through a national task force, so there was a whole lot of different members. There were doctors, there were regulators, there was industry. So I'd have to go. I wasn't personally on that national task force, but there was a member from Safe Work Australia on that panel. But we'd have to go through the communiques or request that through that national task force.
I'm just trying to understand the legislative interaction here, whereby Victoria seems to have got autonomy to do its own thing, but New South Wales can't. Do you want to tease that out for me?
Well, we adopted the harmonised laws in 2012. So we signed up then through way of an intergovernment agreement where all the jurisdictions except Western Australia and Victoria didn't sign up. Western Australia have slowly come into the harmonised arrangements, but Victoria have stayed without. A lot of their laws mirror our laws, but way back the government decided to adopt under an intergovernment agreement those harmonised laws to make it consistent around the country in relation to work health and safety. So no matter where you worked, the same requirements apply, and we've remained true to that process since 2012.
So by virtue of the 2012 opt-in, we've locked ourselves into this national approach is essentially what we're saying?
That's correct.
Okay, thanks.
I'll now... Mr. Diadam, have you
further questions? Unless there's others who want to have a go.
Just noting that we've got about 10 more minutes until we're expecting the arrival of the Senate candidate. So I will allow you to continue, and then I'll see if there's any more on the other side before we get to 2 o'clock.
Earlier in the proceedings, I asked the witnesses about whether they had received training or onboarding in relation to the safety requirements in terms of handling manufactured stone, and their evidence was that they hadn't. What mechanisms are being put in place to ensure that appropriate training is being delivered to the workforce in the industry?
Yeah, so through those site visits, that's a key duty, that people are trained and instructed and know what they're working with. So that is a duty. So in terms of where all those notices have been coming from is where there's been a failure of those duties. Out of the 220 cases where people have been diagnosed with silicosis, not just in the manufactured stone industry, but since 2017, we've reviewed each and every one of those situations as to how did it happen, who did they work with, where did it go wrong. And as Mr. Williams mentioned in the opening, 16 have gone to full investigation, 7 have since been closed, 7 are ongoing, and 2 are actually being filed in court. So they're on foot at the moment.
So just coming back to the training question, how in a practical sense, how is that maintained? Like, there's no specific training requirements, are there, in terms of handling manufactured stone for individual workers, or what are the specifics of the requirements that are imposed on a duty holder?
So there's 2 things. That code of practice is your rule book. Workers need to be trained on what that code of practice is in terms of what compliance looks like and how to work safely with the stone. So that's one aspect. The other aspect, which was way back when we had the task force in New South Wales, one of the recommendations was to get a national unit of competency, and we've been successful in securing that with the National Industry Skills Council. So not only is it a standalone unit, but that unit is going to be used in any trade course, whether you're a bricklayer, concreter, landscaper, manufactured stoneworker. So by simply having that standalone unit available, it's available to any workplace, and it meets a national requirement on how to work safely.
There's no mandate for that training, is there?
Not at this point.
So can I just follow up on that? So if I'm going to cut stone as part of my livelihood, as part of my trade, so to speak, there's no requirement for me to do those units of competence?
No, and when we ran the task force, that became very obvious very early on. We looked at all elements of government, all elements of whether it was the health sector, safe work, the education sector, all the way through the chain, and that's where there was a gap of where is Silica being spoken about in trade courses or any sort of formal training. So that gap's been closed in terms of, but that unit is available for people to access.
But isn't this the relevant, and I would use the analogy of other trades, like, for example, plumbing, electrical, where you have a licensed, qualified regime that's called up in the legislation, isn't that the utility, that you have to do those units of competence again?
Equally, you could look at, well, why license? Why not mandate the unit of competency? Why don't, now if you've got the code of practice, that's mandated. So that's what the assessments is looking at. There's a range of regulatory and non-regulatory options to be assessed as to, well, what will this licensing bit do? And it might be that there's something else. As I said, it could be mandating that unit of competency. So that's what this assessment is going through to ensure that the decision made is the right one that will solve the problem.
Can you understand the frustration of participants in this industry, particularly the witnesses we heard from this morning who have suffered physically and materially from this, that whilst we wait for regulatory assessments and inquiries and hearings and reports and national task forces, people are actually dying and suffering from this, and the public looking in on this would think, well, we actually need to get out in front of the game and actually just bite the bullet and do it. So, I mean, I'm not blaming, because you're constricted within the parameters of what government tells you you can and can't do, but can you see the frustration with politicians like ourselves and people like this who are suffering with this?
Oh, 100%. Not a day goes by where we go home to work having a great day. This is hard work. It's we can't offer enough to these workers that have been impacted. It's not okay. Our condolences go to them. But what we are doing, as I said, is improving the industry for where it is now and for the future. So, as I said, it's we go home with these. We don't have the disease personally, and I can't imagine having that disease. But in terms of the work we do, we are going at it, and we haven't lost sight of it in the time that we've been given this opportunity to close this gap on this industry.
And if I could just clarify, just to, I guess, further add to the education question, I guess, if our inspectors, do form the view that workers are clearly not trained appropriately to do the work they're required to do, notices can be issued in relation to that. So there's not a total void there in terms of workers not, being afforded the appropriate training. There's a general obligation for workers to be provided with the skills they need to do that work and do it safely. And our inspectors won't hesitate to, use their tools to secure that as required.
How does an employer demonstrate that their workers have been trained?
There has to be evidence, there has to be records. So whether that's they've shown training certificates, they've shown what they did on site, even toolbox talks, everything. We collect all evidence and then we would determine whether it's adequate or not.
If they're competent.
How can you be sure that the training is comprehensive? Like in the absence of some licensing scheme or, a certificate of competency being issued to an individual worker, you can't be sure, can you?
Well, we also are watching the practice. So while we're there, we're watching the work being undertaken, that it's been done safely in accordance with the requirements, and now, as I said, with that code of practice, that it's done to standard.
I mean, it's a relatively volatile industry, isn't it? Like it's from accounts that I've heard, there's a high degree of called community participants. There's a lot of people circulating through the industry. How can you be sure that the workers who are potentially exposed to this hazardous material actually have the requisite knowledge to protect themselves? You can't be sure, can you?
Well, all of our materials are translated into the languages that match that industry, and we take interpreters if required, and we have done and will continue to do. So in terms of ensuring that anyone at risk in that industry receives the same attention from Safe Work, as I said, and we use interpreters, and we continue to use them. We've translated materials. There are a number of tools that, including our website, you click on the language and it converts to the language for that worker.
We received evidence in the earlier hearing around the obligations to notify in the case of asbestos if the monitoring indicates that the levels of exposure are higher than permitted. There is no comparable requirement is there in terms of silica particle
No, and there isn't for
detection
asbestos either.
being required to be notified to the regulator, is there?
No, nor with asbestos. There's clearance certificates that are done on site where essentially once it's removed, a licensed asbestos assessor would assess that it's within requirements and issue a clearance certificate. But as I said, there's no notification for asbestos or silica around the exposure standard.
So clause 475 of the Work Health and Safety Regulation requires air monitoring notification.
So clearance certificates?
Yes.
Is that the section?
So, I mean, the evidence from the Australian Institute of Occupational Hygienists was that clause 475 describes air monitoring is required immediately before and during the removal of licensed asbestos work. That's correct. 476 then outlines that if respirable asbestos fibres are recorded to be over the 0.02 fibres per cubic metre, then the work must stop and the regulator must be notified. But there's no equivalent requirement in terms of respirable crystalline silica, is there?
In terms
if a workplace is conducting air monitoring and the detection indicates levels above the mandated minimum, then there's no requirement for the regulator to be alerted to that, is there?
No, it is a requirement though in the law that no exposure standard should be exceeded, so there is a penalty in that respect. But in regards to air monitoring for silica, and you might already be familiar with it, the samples are taken over a course of a week and sent to a laboratory, which takes over a month to come back. So the work's been continued in that period. What I mentioned earlier about the research we're doing, we will have in market by June real-time silica detector that will go on the wall. There'll be rebates available to make it obviously something to purchase, and that will actually set off an alarm in situ while the work's being undertaken. So that, as said, is the space that we're in at the moment in relation to it. But in terms of air monitoring right now, the results are taking up to about a month to, because the occupational hygienist must be used. It's sent to a laboratory, or they have to monitor it generally over about 5 days. It's sent to a laboratory, so it's about a month for that process to happen.
But either way, you don't hear about it if they've exceeded the standard, do you?
No, so that was a task force recommendation for that we presented to Safe Work Australia.
That technology already out, isn't it?
It exists.
You measure it on site, it's already out, isn't it?
No, it will be in market around June this year. So we've procured that through a research project.
Ms McCall, just quickly, that on that section 155, I've had that spreadsheet that you attached. According to the analysis I've had done, that they can only see 3 section 155s listed in round 2. When was what was the operable time frame for round 2? Was it 2020, was it?
Around, that would be probably close to the mark.
So 3 section 155s listed, but all non-silica is the information I've got. Does that surprise you?
I'd have to look at the data. I don't have it in front of me to be able to comment. And what those section 155s were actually for, they could have been quite far-reaching in terms of what they collected. But I've taken it on notice.
I guess the concerning thing is they're saying that they're all the 155s were all non-silica related, so they haven't even issued any for silica. Because that spreadsheet contained multiple substances, it wasn't just silica.
Yes, however, as I said, without having the information in front of me, there's been section 155s issued also on the suppliers. So they're not a site, they're not a fabricator, but there's also been them issued on the supplier, the ones that have brought the stone into the country, and that's been issued twice now.
And they weren't in that spreadsheet, were they?
No, because the request for us was the compliance of the 255 sites, and that's all that's representing. But we can broaden that response on notice if you want us all section 155s, but we've issued them also on suppliers.
Can I ask perhaps just as an initial question, if you could just elaborate on the current requirements around health screening and ongoing health monitoring. Can you just explain what the current requirements are?
It's probably more of a question for iCare this afternoon. But however, in terms of
employers,
yes.
the obligations on employers to.
So the Code of Practice defines how often a person should be screened. In terms of our visit program, because of the nature of the risk, we enforced and issued notices for all workers to be screened. So we've done that. Generally, as I said, the code now defines for that industry how often they should be screened. It's basically at commencement of employment and then periodically based on the code in terms of frequency. But once you're, I guess, if you are being screened by iCare, whether through the lung bus or at their clinics, which is the majority of people, they're then on their database. So they are then in a program of being contacted that they're also due for screening through that way. So at this point in time, as I said, we've screened 1,152 workers, which, as I said, is showing that 77% of those that unfortunately have the disease were at 1%. And out of that, as I said, you're looking at about 7% of the manufactured stone industry had developed silicosis as a result of their work. So
every site that was visited, every site that was visited or every site that was identified by the suppliers received a notice requiring them to get their workers screened. Is
yes,
that correct?
Unless they'd already screened them. So a lot proactively have been doing that, and iCare offered that screening at no cost.
I'm just going to pass to the Deputy Chair, noting that we've got about 10 minutes left, and I'm waiting to see if Mr Shoebridge is actually going to arrive before the end of the session.
Thank you very much. Thank you, Chair. Can I ask both of you together, do you report separately or together directly to Ms Rose Webb in your organisation?
Rose Webb has retired, so she's so Natasha Mann is now the Deputy Secretary of the Better Regulation Division. Yes.
And do both of you report directly to her, or
I report directly to Rose and Ms McCool
to her successor?
To Natasha.
That's okay. Yeah.
Mann and Ms McCool reports directly to myself.
Okay.
Yep.
Okay. I just have a piece of correspondence which I'd just like to take you to and ask a question.
This one here?
Yeah. It's actually a copy of what is a significant piece of correspondence that was CC'd into to Rose Webb, going back to October last year. I just want to draw your attention to the second page, which has got the list of co-signatories. And I'll just allow you to sort of just review who was on there. There's quite a significant and rather impressive list of pretty well-known and highly regarded organisations. And some of the names and some of the signatures are probably familiar to you. I mean, they're particularly in the medical area, some clinicians. But just taking you back to the first page, the piece of correspondence was CC'd into Ms Webb. I mean, we don't have time because we are pressed to go through the content and the attachment in detail, but can I summarise it in these terms that it's almost, if we could describe it this way, a call to arms, so to speak, to deal with this issue. I mean, we have been dealing with this now for a period in terms of understanding it's just potentially a clear and present danger. It is a clear and present danger, and I have to say it was particularly moving this morning to have two gentlemen give evidence who, you know, to be quite honest, have been significantly affected by this, and perhaps, to be frank, once again, if I may, their lives may well be shortened as a direct result of this contraction of silicosis. So probably wouldn't be surprised that we are a little bit edgy in pushing to find out how we can move this along, so to speak, and hence the fact that we're inquiring into this matter again. And it does strike us, and I speak for myself, but perhaps other community members can speak for themselves, that this actually needs a sharper edge to it, moving it along quicker than otherwise it is, because we have particularly all those that have been affected up to this point and looking backwards. But then we've got at the same point, looking forward, the potential for individuals to be contracting silicosis. So we need to be dealing with both at once. And as we see it, or as I said, I should say, the notion of actually having a licensing scheme, and through that one will be able to have an ability to track the workers that work for those entities that actually retain and hold a licence, gives us, or would create a sense of what is the universe of what we're looking at, the universe of the problem, or the issues potentially there. And that's why I'm sort of quite befuddled by the fact that New South Wales hasn't proceeded with this. I mean, I do understand, there is the connection to the national approach, but gee whiz, I mean, without sort of, exaggerating it, people are actually dying from silicosis, and if that doesn't sort of move us all to want to try and deal with this and move things along quicker than I think is the case, I mean, what does? What does?
And as I said, we're in agreement with that. Just looking at this letter and just quickly digesting what it's talking about. This letter reads to me that it's acknowledged the work in the manufactured stone, or engineered stone as some call it, industry, but it's asking for it to go broader into all industries and having regulation across basically wherever silica exists. I can tell you that is a discussion that is ongoing. The only issue with the other industries is they are performing a lot different, a lot better. But in terms of, as I said, silica's in pretty much anything that's sand-based, if that's the direction to head in. But we cover all industries, no matter where they are. There's, as I said, various extra things that have been applied to manufactured stone industry, which everyone's acknowledged needed the most attention. But certainly, as I said, the eyes are on anywhere that silica belongs, because as you know, it's in bricks, it's in concrete. Natural sandstone is also in the 90% silica, and that's just nothing that we can remove from the Earth's crust. That's just how it is. So the sandstone is actually sitting really high with manufactured stone, but also the manufactured stone suppliers are starting to make it with lower concentrations. But I think what this letter's saying, if I'm reading it correctly and quickly, is that anywhere where silica exists, it needs to have, I guess, a portfolio on how it's to be managed. Would that be?
Can I just suggest to the witnesses, for procedural fairness, given that it is a detailed letter, if you are, I guess, seeking to provide a detailed response, perhaps it is better to be done on notice, because I think procedural fairness dictates that we can't just provide you a document of 3 pages and expect you to absorb it and then respond to that immediately. So I think, and I know Mr Donnelly is extremely fair on this, so if there are detailed questions, perhaps it's better to be taken on notice.
There will be some complications, but what I'm getting at is that we collectively have a significant issue here, a significant issue. I understand from earlier comments about putting into perspective in the whole scheme of things where matters to do with particularly the matter of manufactured stone fits into the whole range of matters that Safe Work deals with. But what I'm saying here is that there's quite a genie out of the bottle here, isn't it? If I could put it in those terms. And it really is inviting some pretty serious reflection about the full understanding of the lengths, widths and breadths of this, and to really understand that it's deadly, potentially and actually. And I mean, I don't know what one does to drive that home any stronger than actually put it in those bold terms.
Yeah, what I can assure you, with 40,000 chemicals in Australia, there's around, and I'll have to get the exact, it's about 18, 19 that are listed as the most hazardous. Silica is on that list. So it has an exposure standard against it for those reasons. So it's not that it's not important in terms of it. As I said, it's in the list of the most hazardous in the country, knowing that it's also in natural product.
We've got a few 2 minutes left, so have you got a...
The air monitoring equipment, what does it cost for those air monitoring units?
So in terms of if an occupational hygienist came in, their costs are around to do it for you, anywhere from $10,000 plus. The cost of, and that's just once. So if you came back again or you were doing it once a year or however often, the cost of this real-time detector is looking at around the $18,000 mark at a one-off, with a rebate from SafeWork and a rebate from the supplier to bring that down a bit. So the ballpark's looking like 15 or 16,000, meaning a one-off purchase, and it's detecting it all day, every day, in real time, and sets off an alarm if it's being exceeded.
So in the interim, is there any assistance for the one-off air monitoring costs to defray that to business?
Not at this point.
Okay, so the none currently, and if and when, well, you'll sound pretty confident this is going to come to market relatively soon.
Yes.
There will be an out-of-pocket expense to the business of around about 16 post-rebate.
Yes. And if I can just quickly add, then further research over the next 2 to 3 years to make it a wearable device on workers. So that research is ongoing, but the gap in the system was getting those results in real time, then waiting a month for it, where work's been continuing, and sometimes hard to identify, well, where did it actually happen? So this, as I said, is where we have been very active in this space to bring things into real time so that people are stopped when the exceedances are occurring.
Well, very quick, Mr. Diadam.
Coming back to that question around the health screening, when you issued the notice, what provision were you actually relying on if there's no specific obligation on the employer to conduct health?
I'm just going to go off the top of my head. I think it's clause 376. I could be wrong.
If you want to take it on notice, that's fine.
Yeah, I can take that on notice, but it prescribes when there's harm or risk, we can direct health monitoring, or particularly if we believe the exposure standards being exceeded.
A good quick question. Thank you, Mr. Diadam. With that, I'm going to draw this session to a close. Mr. Shoebridge has missed his call. However, that's the situation. The questions that have been taken on notice, the Secretariat will be in contact with you and we'll have 21 days to table those. We'll now be breaking for a short moment, and at 2:30 we'll be returning with the final session of the day. Thank you very much.
Thank you, Chair. Thank you, members.
Thank you. Well, welcome back everybody to the final session of today's hearing. I'll now ask the next set of witnesses, starting from my left, to state their name and position title and swear either an oath or affirmation.
Thank you. Dr. Nick Alsop, Group Executive Lifetime Schemes at iCare, swearing the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much for that. And just a reminder that it's always good to have the microphone nice and close, just so that we can all hear each other, but also it really does help with the broadcast and also for Hansard. Mr. Harding.
Thank you. Richard Harding, CEO of iCare. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Harding. Mr. Dent.
Adam Dent, Chief Executive of the State Insurance Regulatory Authority. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Now, would any or all of you like to make a short opening statement? And I'll invite Mr. Harding. Actually, I'll invite Mr. Dent to kick us off today.
Thank you, Chair. And thank you to the committee for inviting me to attend today. I was appointed as Chief Executive of the State Insurance Regulatory Authority in July last year, and it's in that capacity I'm here today. The Dust Diseases Scheme plays a significant role in supporting the quality of life for workers whose occupation exposes them to hazardous dust. That role extends to their dependents. The scheme assists with compensation benefits, medical and healthcare and support services, including domestic assistance and mobility aids. The scheme acts as a critical social safety net for the people of New South Wales who suffer from dust diseases. The Dust Diseases Scheme is not subject to independent regulation of claims, conduct or prudential functions. CIRA plays a relatively limited role in the Dust Diseases Scheme, and it is one defined in the Workers' Compensation Dust Diseases Act of 1942. The Minister for Finance is the responsible minister. CIRA's regulatory role in relation to the Dust Diseases Scheme is limited to two specific functions. Firstly, CIRA's role is to determine the contribution to be paid by insurers to the Workers' Compensation Dust Diseases Fund. iCare acts for the Dust Diseases Authority and manages the Dust Diseases Fund. CIRA's second function is to index the compensation payments for dust diseases, broadly based on the Workers' Compensation Act of 1987, provisions for exempt workers and death benefits prescribed in Section 8 of the Workers' Compensation Dust Diseases Act of 1942. Beyond this, CIRA is actively, though, engaged in supporting both national and state prevention initiatives. CIRA supports national strategies focused on occupational lung disease and is a member of, and I now chair, the Heads of Workers' Compensation Authorities of Australia and New Zealand and Safe Work Australia's Workers' Compensation Strategic Issues Group. At a state level, CIRA collaborates with stakeholders including the Dust Diseases Authority, Safe Work New South Wales and New South Wales Health to support programs of work related to silicosis. Following the recommendations made in the 2018 review of the Dust Diseases Scheme by this committee, CIRA commissioned research and liaised with key stakeholders regarding updating the list of compensable dust diseases contained in Schedule 1 of the 1942 Act. The research work undertaken by Professor Tim Driscoll, who is known to this committee, was finalised in September 2021, and the report recommended 5 additional dust diseases be considered for inclusion in the schedule. CIRA has provided iCare with all of the evidence and actuarial documents that were requested by this committee for it to consider and provide advice to government on any proposed amendments to the dust diseases schedule. We'll continue to support iCare and with any requested and proposed amendments. I look forward to seeing this work progress. I thank you again for the opportunity to support the committee with your inquiry.
Thank you very much, Mr. Dent. Mr. Harding, would you like to make your opening statement?
Thank you. And good afternoon, everybody. And again, thank you all for the opportunity to be here today to discuss the important work iCare does for the people who are part of our dust diseases care scheme and for those who have been exposed to hazardous dust in the New South Wales workplaces. Firstly, to the financial position of the scheme. When the scheme commenced almost 100 years ago, it had no assets other than a small operating float. The design of the scheme was such that the contributions collected from employers would cover the cost of paying the entitlements and the administration costs of the scheme each year. Due to this pay-as-you-go design, the funding ratio doesn't reflect the financial viability of the scheme, as it will always collect contributions to balance outgoings, and this is enshrined in the legislative design. Due to differences between the estimated and collected contributions and the cash outflows over the years, the scheme has accumulated assets over time. These have grown with investment income to the point where the scheme now has $1.2 billion in invested assets. These assets and the associated income benefit scheme stakeholders, including employers in New South Wales by offsetting their contribution requirements, the victims of dust disease and their dependents through more empathetic processes and enhanced entitlements, the Dust Diseases Board through investment in research, the Dust Diseases Tribunal through supporting their operations and the build of new digital solutions, and SafeWork New South Wales through the co-investment in real-time silica detection research and supporting their awareness campaigns. The financial position of the scheme has also allowed the remediation of past compensation without passing the cost on to employers. The remediation program stemmed from the past misinterpretations of the 1942 and 1987 legislation around entitlements. iCare did not create this decades-old issue, but we are fixing it. All current workers have been contacted and payments of $9.6 million have been made to date. The executors and beneficiaries of deceased estates are currently being contacted and payments are being made in accordance with the wills and other instructions. An additional $1,000 has also been provided to each impacted person or estate to assist with advice around the payment. This process is almost complete, with final contacts and payment to be made by the end of June. There's been some recent media attention around the potential growth in silicosis claims, particularly given the popularity of manufactured stone products and the significant number of tunnelling projects in New South Wales. This is a significant concern to all of us. It's important to note this is often a slow-moving condition, and its true magnitude may not be known for a number of years. I can speak to the current data, however. iCare, in partnership with SafeWork, has been to every manufactured stone workplace in New South Wales, offering a comprehensive subsidised screening service, an education program on risks with silica dust, guidance materials for minimising risk of exposure, and vocational support for those who wish to leave the sector. The screening program identifies people working in the sector with early signs of silica-related diseases. Prior to 2019, the scheme accepted an average of 9 silica claims a year. Today, this is around 40. There was a spike in claims in 2020 following an extensive awareness campaign and increased screening. Case numbers are not expected to increase significantly in the near future, as many cases have now been identified and brought forward. Improved awareness should lead to more effective preventative measures in workplaces. As a result, we are not anticipating an impact to premiums in the short and medium term because of silica disease. It is worth noting 95% of participants of the scheme are related to asbestos diseases. It is a matter for both state and federal governments to consider further preventative measures and actions on dust diseases. Our comprehensive subsidised lung screening program conducts over 4,000 tests each year, including, as I mentioned, making tests available to every manufactured stone workplace across the state. Our screening program includes the mobile lung bus, taking the testing right across New South Wales, the specialised clinic in Sydney, as well as leveraging external providers. Medical screening examinations are provided free of charge for any New South Wales worker who believes they are at risk from past exposure to hazardous dusts in their current or past employment. All workers exposed to manufactured stone dust are provided a CT scan. Workers who choose to leave the industry after being exposed to hazardous dust are referred to a vocational rehabilitation provider to undertake vocational assessment. This helps the worker identify suitable alternative work and provides ongoing support to ensure their goals are achieved. Workers who get a job that pay less than their silica industry employment are entitled to receive make-up compensation payments. In addition to this important work, 37 research and innovation grants worth nearly $8.5 million have been approved by the Dust Diseases Board in the past 5 years. The Dust Diseases Scheme is currently supporting around 1,300 workers with approximately 300 new cases each year. In addition, over 3,000 dependents are supported under the scheme. Around $120 million entitlements is paid to these victims of dust-related diseases each year. It is a privilege to be able to support these people. The dedicated and passionate team at iCare are deeply committed to helping people in their hour of need and providing them with the support they need to live and in some cases die with dignity. We look forward to supporting the committee in its inquiry and the review of the dust diseases schemes.
Thank you for that, Mr. Harding. We'll now turn to the... sorry, Dr. Alsop, did you have an opening statement on Mr. Harding? Covered yours. Thank you. We'll now turn to questioning, and I believe Mr. Buttigieg is going to kick off for the opposition.
Thanks, Chair. Look, I might just open up by sort of framing this in a general discussion which we've been having today vis-a-vis the reactive approach versus the proactive approach, and if I could put it in crude terms, the educational, monitoring, regulatory oversight approach versus the cutting it off at the supply source and licensing. You're at the financially pointy end of all this, where you actually see the obviously the human element, which is what matters here, but the cost of that in terms of the cost in premiums and to employers and the solvency of the fund, which you've outlined there's no issues with. I want to get a feel for whether or not your organisations have a perspective on whether or not the current approach that the government's taking via that, what I would call a reactive approach, is going to be sustainable in the long run. I mean, notwithstanding the comments that you made, Mr. Harding, which seem to imply that things are starting to level out, but we don't know that for sure, do we? So I just want to get your feel for whether or not you think a more proactive approach, because this is a vicious cycle, isn't it? Because if essentially the default situation we've got now is that there's no ban on the product coming into the country or the supply thereof. There's no licensing regime, therefore there's no custody, legal custody or financial penalty really, other than fines and on-the-spot checks. My question is that system good enough for this to be financially sustainable in the long run? And even if it were, should the taxpayers be footing the cost of this when a more presumably preventative approach could be taken?
I'm not really in a position to comment on your question in regard to the adequacy of the regulatory framework, because that's really not in our bailiwick. That's really something to have a conversation with SafeWork about. In terms of the financial viability and sustainability, well, the scheme, given its design, is actually designed to be able to support people with dust injuries in perpetuity through the model that I described in my opening statement. The fact that contributions are charged on the basis of the expected outgoings each year means that it's a pay-as-you-go model. So effectively, it is viable into the future no matter what. We are having the benefit at the moment of the fact that the scheme has accumulated $1.2 billion in cash and assets, and we currently use that money to subsidise the cost to employers, so that the intergenerational issues that exist in the nature of this product, given the time it takes for the development of the disease, can somewhat be ameliorated. So we have held for the last 2 years the cost to industry at $70 million. And as Mr. Dent pointed out, Sarah work out how that then is allocated across the employer groups. That has resulted effectively from, over the last 2 years, about $118 million subsidy from that investment income. So the scheme is viable for both those reasons, because it has that, we're in the lucky position that over 100 years we've accumulated that asset, and in the fact that the design of the scheme enables it to be ongoing for perpetuity. I think the goal for us, from iCare's point of view, is to be there to support people in the situation that, the unfortunate situation where it arises, they do have an impact from a dust disease, and to be as involved as we can be in the preventative side through our screening program with SafeWork New South Wales, so that we can identify as early as possible and get those people into treatment as quickly as we can. The regulatory issues and the preventative issues beyond that are really not in my bailiwick, and they're probably a matter for government that it needs to be addressed.
Looking at it from a cost-benefit analysis on behalf of people of New South Wales, and in particular the people who are affected by this and the employers who have to pay that levy, you'd be asking yourself, wouldn't you, the logical question would be, well, if you've got $1.2 billion in assets and you're using that income stream to ameliorate premiums, isn't it better to eliminate that cost altogether and use that $1.2 billion more effectively by trying to prevent the thing happening in the first place. So there's just a kind of a self-sustaining little business model, isn't there here? I'm not being facetious. It's just, if you were looking at this from the perspective of cost benefit, you would, that's the obvious question, isn't it? And I know it's not in your remit to make judgments about that, but wouldn't you think that that was a reasonable perspective to take, and have your bodies made any representations to government along those lines? We're not talking about hypotheticals, are we, here? Because there's other jurisdictions which have gone further, like the Victorian one with licensing, and I'm not sure what the financial side of that equation is and how better or worse off they are, but presumably these are questions that are actively discussed in...
Well, in reality, the answer to the question is no, because it isn't in our bailiwick, right? So the advice that they would seek from that would be from Safe Work and other parts of government. So unfortunately, I'd love to answer your question, but I'm really not in a position to give you the answer. The approach that we're trying to take is to be in the process as early as we can through the screening program, be out there as frequently as we can by circulating each year and attending each manufactured stone site, so that we can have as much early identification as possible to enable people to identify it, to change their vocation if that's what they'd like to do, and to be aware of the issues and to create awareness. And we do that in partnership with Safe Work, but the issue of, as you've raised, of preventative regulation is really a matter for Safe Work and for other parts of government, I'm afraid.
I mean, can I jump in on that, on the screening question? Are you confident that you've got everyone, that you've actually reached every worker in the industry, that everyone's been screened? Like, what's your assessment about... Safe Work assures us that they've visited every site, they've issued sufficient notice so that employers have been required to get their workers to be screened. Presumably that's been done in close cooperation with ICARE. How confident are you that everyone's been screened? What's the sort of hit rate?
I'll ask Dr. Alsop to provide you a more detailed answer, but the high-level answer is yes. Yeah, we are somewhat reliant on Safe Work for that outcome, but yes is the answer. But do you want to provide a little bit more context?
Absolutely, thank you. So Safe Work have advised us that they believe there are between 1,100 and 1,500 people working in the manufactured stone sector in New South Wales. Over the past 3 years, we've screened 1,200 people identified as working in that sector, and we continue that screening process today. So I think in April this year, we're visiting the Caesar Stone site in New South Wales and screening over 100 of their workers at that time. So to the extent that we can, based on the information we have from Safe Work and our own screening records, we do believe we have reached the majority, if not all, of the people in the manufactured stone sector.
Can I ask you, so does Safe Work provide you with contact details of the workers? Is that the level of information that you're provided with?
It's engagement with the employers, and then in booking their workers in for screening, we obtain those details.
I see. So in terms of the bookings, what's the sort of hit rate? Like, if you get a booking, does that mean that the worker gets screened, or is there a proportion of drop-off where some workers actually don't front for the screening?
I would have...
What's that percentage?
Yeah, I would have to come back to you on that percentage. I don't believe it to be high, but I would have to come back to you with an actual number. I think workers know, like employers know, it's their obligation to have their workforce screened. It is in workers' best interest to be screened in order to identify what risk of exposure they have. But we can't force people to be screened either. Do
you get access to the information that's now being provided as a result of silicosis becoming a notifiable disease?
We provide notifications where we identify somebody who has contracted the disease. We provide those through to New South Wales Health.
And does the information flow back the other way so that Health advises you of workers or work sites? So presumably there's a notification to Health. Health then says, OK, well, we need to reach out to this worker to get more details about the environmental circumstances that led to them developing the disease. That might then identify a worksite where other workers may have been exposed. Like, can you explain how that information loop works so that we're catching as many of the workers who might be exposed? And I suppose a sort of cognate question with that is, has that process then exposed work sites that weren't known to be identified through the safe work process that's been undertaken with importers and suppliers?
Yeah, and you may well be identifying a gap here, because I do not believe, but I would need to investigate and check, but I don't believe New South Wales Health do detailed industrial histories on people who present to them directly with dust-related disease, but I would have to take that on notice and come back and check that. But where a worker is identified as having a dust-related disease, they are usually then legally represented and find their way through to the dust diseases scheme through that mechanism or through the tribunal.
Anyone who gets notified, ultimately they appear on your radar. Is that the case?
Yes, they would likely come through. We would receive information around their screening. We would then gather industrial history information ourselves and refer that to our medical assessment panel to assess whether or not they have a compensable disease.
Adam, are you I was going to look to rotate the questions around. Just one more, okay.
Does that include posthumous notification? So if someone is posthumously identified as having silicosis and that's been notified to health, is there some way that information then makes its way back to iCare in terms of dependence?
I would have to take that away on notice. It would probably only occur if the dependents then sought legal representation and pursued a claim against the scheme. So
there's no automatic process. So there's a gap there in terms of the information flow, perhaps.
Potentially, yes. It's something we're pleased to take away and investigate.
I'll call that a half for one, but it's a Friday afternoon, so I'll be generous. Mr. Shoebridge, you've got the call.
Oh, thanks, Chair. Nice to see you all. In terms of the estimate of between 1,100 and 1,500 workers in the industry, you're relying upon Safe Work for that estimate, is that right?
That's correct.
And that's at any one time?
Yes. Sorry. Working in the industry at the moment that's what that estimate has been presented to us as.
And you have screened 1,200 people, 1,200 distinct people or 1,200 screenings?
1,200 screenings. So there's a requirement for, based on work health and safety standards, for people exposed to silica dust to be screened every 3 to 4 years. Where that exposure is heavier, that requirement reduces. So in the case of manufactured stone, where the exposure is heavy, more frequent.
Explicit requirement, Mr. Alsop, sorry, David. Is that an explicit requirement?
3 to 4 years.
The requirement for screening? Because the early evidence was that it's not explicit.
So the work health and safety standards do stipulate a screening requirement every 3 to 4 years, is my understanding.
I'm just going to ask that we don't...
Sorry.
No, I don't mind.
No, but more than that, it's actually talking over the top of people. I prefer that if witnesses are speaking, that they have the opportunity to finish their answer before we interject.
So 1,200 screenings, but we don't know how many actual workers that is. That's less than 1,200 workers.
I'd have to take that away on notice, but given the focus on going through every manufactured stone site, I don't believe there's a lot of repetition there, but there may be some, so we'd have to take that away and come back to you on that.
And these are largely the manufacturing and the workshop sites that you've been visiting, is that right?
So they are the fabricators, yes. Yep. Based on information from Safe Work, we believe a lot of the installers are tied employees with the fabricators, and so they have likely been picked up in those processes as well.
So you haven't been to any of the multi-level building sites where they're putting in 500 kitchens and 500 bathrooms?
No, we don't visit individual building sites. Safe Work, I believe, do, and would then make notifications or lodge notices with those employers requiring them to have workers screened.
But a very large chunk of the workforce aren't actually in the fabrication sites and the workshops. A big chunk of this is actually happening distributed across the whole state in building sites, and many of those workers would never go back or even have a direct contact with the fabrication site. So how many of those workers are there?
So again, I can only rely on the information that we've been provided by SafeWork, who have indicated that between 1,100 and 1,500 people work in the manufactured stone sector. It's probably a question for SafeWork as to what the split in that number is between installers and fabricators.
I've got to say, between 11 and 1,500 people couldn't come close to installing the number of kitchens for the northern suburbs of Sydney, let alone for all of New South Wales. How do you come to the figure that 11 to 1,200 people are the number of workers in the industry? Because as I say, it'd take 11 to 1,200 people to be just installing the kitchens on the northern suburbs of New South Wales for bench tops.
Can I just perhaps take a moment to respond, Mr. Stubbe? So I think you've raised a very interesting point, which is potentially, how we get to those installations, the large. You mentioned the sites where there might be 10 stories of installations going on. I think that's a very good idea and a very good opportunity that we haven't yet identified, but we are reliant on SafeWork to identify for us the exposure sites and the places where we need to go and do the screening. So we work with them to do that.
Yeah, Mr. Harding, when I asked this morning, I put it to Ms. McCool, I think, that the Section 155s, which were the mechanism for determining out into the never, there was none issued in 2 years. So, I mean, do these things ever get discussed?
Yes, they get discussed. But I think I'm acknowledging the point that Mr. Stubbe just made, which I think is valuable.
Well, so if you can on notice indicate what strategies that there may be possible or you'd be considering to adopt to get to those. And the reason, Mr. Harding and Mr. Allsop, Dr. Allsop, one of the reasons why I'm particularly concerned about those sites is when you talk to the workforce, they're the ones without the dust extraction, they're the ones without the adequate masks, they're the ones most exposed to significant inhalation of silicosis, of silica dust, and they're the ones we're not getting to. Do you understand though?
Well, I think there's a leap of faith being made that we aren't getting to those people. So I'm not objecting to your point. I'm just saying there's a leap of faith being made that we aren't getting those people because we aren't in those sites. Those people are employed by the installators. They're employed by the companies that are there. We are working through those. But I think I'm agreeing with the point that you're making, but I just think let's not make a overly extrapolation of that we aren't getting to all of them.
Mr. Stubbe, sorry, do you mind if I just make a note, which is the use of the words leap of faith concerns me greatly when we're talking about dust diseases. Do you think you could just expand on that just a little bit? Because having sat through these a few times, I think that
I took Mr. Harding to mean that we don't have necessary and evidentiary base to link A and B.
That's why I was just giving you the opportunity to actually.
Thank you. Yeah, there's no evidence to suggest that those people aren't getting.
Well,
in the other.
All I'll indicate on the record is when I talk to the union, when I talk to people in the industry, they tell me that there's an entire workforce out there that isn't employed by the fabricators and doesn't go on site, doesn't go to the fabrication site, but is out there only doing installing. Many of them are subcontractors, many of them work for labour hire, many of them have no direct contact with the fabricators. That's what I've heard. It appears to be different to what you're hearing and what SafeWork has heard.
I read that evidence this morning, in fact.
Well, I appreciate you bringing it up because I think it's a very important issue. So I'm very happy to take that away and work out what the gap is and we can reply.
And has anyone just done a basic check of the amount of this stuff coming into the country and whether or not 12 or 1,500 people, if they were working full-time every day, could shape it, cut it, form it and install it? Because for me, assume that New South Wales is a third of the construction industry in the state, in the country, those 12 or 1,500 people, given how much of this stuff I see everywhere, would have to be some of the most dynamic 500-hour-a-week workers you could possibly imagine to be installing that amount of stuff across the state. Has anyone done that kind of check as to whether or not the volume in any way could equate to that sort of workforce?
Again, Mr. Stubbe, you'd have to talk to SafeWork about that, and that's really, we're here to be responding to the identification of safe work and operating the screening, and to be there to manage the claims.
Low-dose CT scans, is that your primary scanning mechanism? That's what the doctors say, that's what the National Health Advice is. Low-dose CT scans is the best way of finding silicosis. Are we doing that yet?
Yes, absolutely we are. It is one of our identification tools. We still do X-rays as well, but anybody in the manufactured stone sector is offered CT scanning at no charge to them as part of the diagnostic process.
So of the 1,200 scans, how many of those have been low-dose CT?
So everybody that we're screening in the manufactured stone environment is offered low-dose, or is offered CT scanning. I'd have to come back as to whether it's all low-dose or not.
Is there a delay in getting to a low-dose CT scan? Do you take that to the workplace?
Unfortunately, we're not able to equip our lung bus with a CT scanner. The calibration requirements of that particular piece of equipment is such that it doesn't lend itself to being mobile. What we do is, where people present to our clinic in Sydney CBD, we get them same-day referrals to a local radiology practice, I think at Sydney Hospital, where that occurs, same-day CT scanning for them. Where somebody is seen on our lung bus, we arrange for a radiology practice in their area to provide that CT scanning.
So there's no guarantee they're low-dose CTs. These are just...
I'd have to come back to you on notice on that.
Can you come back to a notice on how many of these screenings have been CT scanned, how many of them have been low-dose, and what the strategy is, I assume, and correct me if I'm wrong, to get into 100% low-dose CT scans if we can. Is that the strategy? Is that the plan?
Absolutely, that everybody gets the appropriate diagnostic tools in order to assess their impact of any silica exposure.
All right. The annual report on the dust disease scheme, and I'll read from it directly, says the scheme's liabilities have been adversely impacted by a higher than expected number of claims and an increase in the expected claim handling expenses, as well as allowances for remediating past underpayments to some workers and revising future payment practices. Breaking that down in part, to what extent have the scheme's liabilities been adversely impacted by a higher than expected number of claims? How much did that contribute to the negative turnaround in the scheme?
Yeah, I've got that here. So I believe, if my screen will scroll, the impact of more asbestos-related sufferers entering the scheme added approximately 77 million to the liabilities of the scheme in the December valuation. Now, this is the result of, we believe, people living longer and healthier lives, and hence living long enough to manifest these diseases and seek compensation through the scheme. So the average age of an asbestos sufferer entering the scheme is now late 70s, whereas many of these individuals would unfortunately have passed away prior to this point due to, say, smoking-related illness or other causes. They're now surviving long enough to enter the scheme. We had projected, given the average age of the individuals presenting, that we would see a decline in the number of people entering the scheme in these more recent years. We haven't seen that decline come. What we've seen is a plateauing in the number of people entering the scheme. So when we say more than expected, it's not that the numbers are going up, they're just not going down in the way we had anticipated.
Well, I mean, my reading of the data, I could be wrong, saw an increase in asbestos claims between 2018 and 2021, quite a significant increase, and it saw an increase in mesothelioma claims between 2018 and 2020, again, quite a significant increase.
Yes, and that came after a period where claims were lower than had been anticipated. So it's one of those things where it's really difficult to anticipate how those claims will emerge, given the really long latency periods between exposure and disease manifestation. So there is a lot of uncertainty around those numbers, and the actuaries are doing their best possible efforts to model those out.
Mr. Shoebridge, do you have
I just have
further
two more questions on finances. Is that okay?
Yep, two on finances, and I'll pass the questions around and come back to you.
The increase in expected claims handling expenses, what does that... what's caused that, and how much does that cost?
So the cost of Sorry, I might. Yeah, if you've got the number there.
So, Mr. Schubert, you will recall in our previous discussion of budget estimates, we talked about the reallocation of expenses between the different parts of iCare as a result of a review by the Auditor General. That resulted in an increase in the corporate overheads being allocated to the dust disease, so we get a more accurate allocation.
Yep. And how much was that?
That's around movement from around, on average 2 million to about 15 million. Yeah.
And then what about the allowance for remediating past underpayments? How much does that cost the scheme this year, and how much will it cost it going forward?
So the remediation, as Mr Harding indicated in his opening address, is expected to be concluded by June this year. So what we've seen in terms of the liability assessment at December is an allowance for that remediation taking a few months longer than we had anticipated. So we had originally anticipated that the majority of people would have been repaid by December, but as that hasn't happened and the actual payment process has spilled out into this period through to June, the actuaries have added a $22 million allowance to the liabilities at December to reflect the fact that those payments still have to occur.
In total, how much has had to be paid out for the remediation?
So in total, we've paid around $10 million to date. We anticipate that there's about $28 million left to pay if we can make contact with all of the deceased estates.
I'm quite generous with the half questions today. Mr Martin, did you want to...
I'll just steal Mr Roberts' microphone. I'm sure you won't mind. A few minutes.
He's also generous.
Thank you for making time this afternoon. I'd like to start by asking how you're assisting workers who have been diagnosed with a dust disease but are still working in dusty conditions, particularly, or in the construction sector, and how you're helping them to move into new occupations.
Let Mr Alsop answer this, if that's all right.
Thank you for the question. We do offer a vocational support service to workers who have been identified through screening processes as having the early markers of dust-related diseases and who wish to pursue other vocations outside of their current roles. It is obviously an opt-in process, so the worker has to want to partake in that sort of redeployment activity. And through that, we spend time working with the individuals around what sort of career paths may be of interest to them, looking at what training opportunities that might require and supporting them to access those and hopefully ultimately through to job placement in a new role. And where that role may end up paying them less than they would have in their current role, then we look at make-up compensation to cover that gap in earning potential as well.
Okay, so particularly if they do not want to, and to be frank, cannot work in a dusty environment or in the construction sector itself, there's that option to be able to do a job in another sector and have the gap covered.
Absolutely.
Is that an option that's commonly taken up, and are you able to?
It is relatively early days in terms of this service.
Okay.
It was not something the scheme had offered in the past because the majority of customers came to us post-retirement age. So with the this younger cohort of silica-related sufferers, it's something that we've had to implement and put in place. So I couldn't come. I'd have to come back to you on notice with how many people have.
That'd be good.
Taken it up. Yep.
That'd be good. Thank you if you could. So, if somebody accessed your services in years gone by, are they able to come back now and make use of this service now that it's updated and with those new conditions?
So anybody who has been a client of the scheme or a customer of the scheme is always a customer of the scheme. So absolutely, if they were to present to us and seek to access those services, then yes, we will provide them.
All right. Are we able to get an update on the remediation of the decades-long misinterpretation of the legislation which has led to underpayments or, in some cases, overpayments for DDC participants?
Yeah, absolutely. So, as you've identified, there has been this misinterpretation of the legislation. It has led to both under and overpayments. If we tackle first off the overpayments, we are in the process of working with Treasury, New South Wales Treasury, on legislation change to address the anomalies that exist within the Act and preserve that level of payment for all participants in the scheme. So we are certainly not looking to claw back any past overpayments, and what we're looking to do is enshrine in legislation the current level of payment, which is at that higher rate in all cases.
Okay.
From a underpayments perspective, we have been actively remediating the identified clients. So all alive workers in contact with the scheme have been contacted and are in the process of being remediated. To date, we've made payments of about $6.4 million to those. I think we have 2 people that we are yet to be able to make contact with, and maybe 3 other people where the payments are yet to go out. So we only have about 120,000 worth of payments still to make in respect of that cohort of currently engaged workers with the scheme.
So to be perfectly clear, if that change were to take place, no one would be worse off if they've been receiving overpayments because of a bungled calculation?
Correct.
Okay, thank you.
No, there's no clawback on the overpayments, and what we're trying to do is maintain payments at that level through legislation change.
All right, thank you.
No worries. Mr.
Hold on, sorry.
Did you want me to wrap up on the deceased estates and the underpayments there as well?
Yeah, that would be handy, yeah.
Yes, so we're still working through contacting the beneficiaries and executors of estates where the worker has passed away. That is proving difficult, and we anticipated that it would prove difficult. To date, we've made about just over $4 million worth of payments to those estates, which has been distributed to the beneficiaries. We still have circa $27, $28 million worth of payments to go, but we are struggling with the identification of some of the executors and beneficiaries in these cases because the records are hard to find, and going back through wills and things like that takes time. So we do anticipate completing this program to the extent that we can make contact with people by June this year.
Out of curiosity, is it a privacy issue or a logistical issue of just finding?
It's the logistics of finding these people and finding the executors, identifying the beneficiaries, making sure that we have the right distribution proportions and things like that.
Thank you.
I'll offer Mr. Donnelly the call now, then I'll come back to Mr. Buddigee.
Thank you, Chair. Thank you very much. My first question, Director, perhaps to it might be Mr. Harding or Dr. Alsop, perhaps not quite sure which, but feel free to respond as you see fit. With evidence we had earlier today from SafeWork, in the opening statement it was said towards the end, I'll just quote from it, I know you don't have it in front of you, but I'll just quote, talking about the National Dust Disease Task Force, quoting, in June 2021, the National Dust Disease Task Force final report was released. I just might pause there. Is ICARE aware of the release of that report?
Yes, we are, and we've provided feedback alongside SafeWork on that report.
Thank you. Well, I just wrote on because I just want to link up the two to just make a connection to see if it's accurate here in my mind. It goes on to say that the Department of Premier and Cabinet is coordinating New South Wales' contribution to the Australian all-of-government response. And then goes on to say SafeWork has provided its contribution to DPC. And there's another sentence which is not what I really want to raise. But with respect to the response by ICARE to the draft, or rather to the National Dust Disease Task Force final report, did you present, or did ICARE present it directly to the Department of Premier and Cabinet as ICARE's response, or was it done through SafeWork to the Department of Premier and Cabinet?
It was done directly to the Department of Premier and Cabinet as ICARE's response.
Okay. So with respect to ICARE's response, did ICARE make any particular comment or reflection or even recommendation about the matter of the establishment of a licensing regime for the manufactured stone industry?
No, we did not. That is a recommendation more appropriately addressed by SafeWork and government. So no, we did not make comment on that particular item.
Well, you say more appropriate. I mean, surely from ICARE's point of view, you have a a significant interest in wanting to know the size and the dimension of the width, breadth and depth of the manufactured stone industry in New South Wales to a quite an accurate level. I mean, that's a fair statement, would it not be? You'd want to know that?
It would certainly aid us in planning for screening services and compensation services into the future. I think it's worth noting...
I'm sorry, just without cutting you off, but I am cutting you off. You say aid. It would be more than aid, though, would it not? It would provide some actual precision for you, not, surely, of actually having eyes on the actual dimension of the manufactured stone industry, surely.
It would add to research and understanding in that regard, yes.
Well, I think it was Mr Harding who actually said that with respect to the understanding or the comprehension that iCare has of the manufactured stone industry in terms of the numbers of employees, and that you rely, that is, I think your words, that you rely on the information provided to you by Safe Work. Is that correct?
That is largely correct, yes.
So you don't have any separate source or access of information to give you any greater precision or knowledge about the size of this industry other than what's provided to you by Safe Work. Is that correct?
And what we can glean from the information on our own records in terms of people who have presented for screening or identified as having silica-related disease.
Yes, and presumably they are within the subset of people of the known individuals impacted by silicosis. That would be right, wouldn't it?
Our health monitoring services cover those who may not have been impacted yet but are in the industry, yes.
Yes. So with respect to Safe Work in their evidence earlier today, they indicated there are they used the figure 255 sites. 255 what are called the sort of fabrication or the manufacture sites. Is that something that you're aware of? Have they communicated that to you, the actual sites, the number of sites and where they are?
Yes, they have, because we've been actively engaged with Safe Work in terms of visiting those sites and screening the workforces there.
So they're the sites, but when one looks at and turns one's mind to the matter of installation, what are you able to say about the understanding, or your understanding, iCare's understanding, of the number of persons involved working in installation? And I deliberately use the word working in. I'm not talking about those who might have an employer-employee relationship and may be working out of one of these fabrication plants doing the work. So they'd be at least presumably on the book, so to speak, of the fabrication plant. Excuse me. But rather the installers. What sense do you have of the numbers of installers in New South Wales?
And to our earlier answer, I think that is a question best posed to Safe Work. We rely on their information in terms of accessing sites, and I think it's...
Well, can I ask you then, what have Safe Work told you are the number of installers in the manufactured stone industry in New South Wales?
So they've advised us that they believe there are between 1,100 and 1,500 people working in the manufactured stone industry in New South Wales. I don't have the split between fabricators and installers in terms of that number. And again, is a question probably best posed to Safe Work. And I think it's important for the committee to understand that in screening individuals in this industry, we have no legal right of access to workplaces. We can't go onto work sites without being invited. So we are heavily reliant on Safe Work and their identification.
Doctor, I understand.
When the witnesses, I just asked that we allow them to finish before we ask supplementaries. Dr. Alsop, had you finished your answer?
I was just going to say we are heavily reliant on Safe Work to identify work sites and provide us a means to gain access, be that through notifications that they issue or guidance they issue to those employers requiring them to screen their workforces.
I understand that, but can I just put this to you? Just imagine this. We know there's 200 or up to 255 fabrication sites in the state of New South Wales that we know of, okay? And that's being communicated to yourselves by Safe Work. And then on top of that, and we all know this from our own sort of just intuitive knowledge, On top of that, there's all the installation work that's going on in the state of New South Wales. How seriously do you think we should take iCare's belief that the total number of people employed or engaged or working in the manufacturing industry is between 1,100 and 1,500 because you were told that by Safe Work and that that's believable? I mean, I just find that myself unbelievable that iCare, the size of the organisation, the resources at its disposal, the, dare I say, the absolute smarts of the people who run it, can buy the line that there are only between 1,100 and 1,500 people working in the manufactured stone industry in New South Wales. What do you say to that?
I do understand the point you're making. We are only able to rely on the information that we have presented to us, and we have no reason to disbelieve the information presented to us. Our role is to provide that screening support and compensation where somebody is identified as having a disease, and we will continue to do that to the best of our ability and continue to partner with other agencies across government in that support
I know
process.
Mr Shoebridge just wants to ask a question, but can I just complete on this question? If you have a number put in front of you, and I understand the seniority of yourselves here at the table, which just honestly beggars belief. Beggars belief. No one in this room believes there's only between 1,100 and 1,500 people working in the manufacturing stone industry. You could go and ask a person, just walk out in Martin Place, pick someone off the corner and say, the manufacturing stone industry, if I'm finished, how many people do you think? And you should say, between 1,100 and 1,500. They'd say, you've got to be joking. No, nothing about it. But this is iCare. How can you possibly buy that and then say to the inquiry this afternoon, you can only rely on the information provided by WorkSafe?
Sorry, I think we may be getting tied up in a definitional issue here as well, because we screen over 3,000 people a year for silica-related illnesses.
Yep.
So this is far more than the 400 or so a year that we're screening from the manufactured stone sector itself. So that 3,000 screens, that includes people working in tunnelling, people in construction, people working for councils where there is exposure to silica. So this may be a definitional issue in terms of manufactured stone versus the broader workforce that is potentially exposed to silica. And so it could easily be that the installers that you're talking about are being picked up through construction entities rather than being identified as manufactured stone employees. So that 3,000 people that we screen every year for silica-related exposure, that may be capturing those. So, sorry, we may have got tied up in the definitional question there.
I know Mr Buttigieg had more questions, and I know Mr Shoebridge indicated he is. I'll pass first to Mr Buttigieg, and then Mr Shoebridge and Mr D'Adam have also indicated as well.
Well, I might just continue along that line because I think it's important. My colleague was pursuing this because if it's somewhat incongruent, you've got people who are, I think they call them actuaries, who calculate.
I think Dr. Alsap knows about those people.
Yeah.
Yeah.
A little bit of experience.
I'm sure you do. Now, it's the function of these people, isn't it, to, within an inch of its life, try and calculate as best they can future potential liabilities so that you can determine premiums and, you know, the liquidity of the fund, all those sorts of things which affect the recipients of compensation, affect employers. And then the idea that there wouldn't be questions asked about the input data which influences those financial numbers vis-a-vis the line of questioning my colleague was pursuing. So in other words, just put it into context again, 255 manufactured stone sites, of which SafeWorks say represent 85% of the total. Let's forget the 15% that we're not aware of for the moment. But if there's the estimate of the top end was 1,500 total of people in that industry, that means around about, what, seven employees on average per manufacturing site. the idea that those sort of very basic back-of-the-envelope calculations wouldn't be fed into those people calculating the finances of such a big fund, it does beg a belief, doesn't it? Like,
maybe if I can help for a minute, Mr. Buttigieg. So the actuarial processes have nothing to do with the establishment of the screening process, because they're two different issues that you're conflating. But in respect to your
sorry,
question...
doesn't the screening then determine part of the problem? In which feeds into the finances as well?
At the point in time where we've identified someone who's making a claim, yes. But if you would let me finish. So I think we've made we've actually answered this question a number of times. I think the point is we are reliant on Safe Work for the information about the sites and the employees. We are, that is the current nature of the process. And quite frankly, as I alluded to before, we have no other evidence upon which to base that discussion, even though it might appear on your intuition that there is a higher number. So we are working on that basis. But as Mr. Alsop has just pointed out, when we do go out and do the screening, over 4,000 lung bus screens a year, we are capturing a broader audience than that 12 to 1,500 people, and they are people exposed in different locations. I've already accepted the point made by Mr. Shoebridge that there are other locations where there are intense exposure sites likely to be occurring. I think that's a very good addition to and we can take that back and work with Safe Work on it. But I don't know that we're going to give you another answer to the question that you and Mr. Donnelly are asking, that there is only this one answer. So,
well, the concern is with all due respect, the concern is that it seems to me as though iCare is effectively outsourcing figures which affect its financial operation to another government body and essentially washing its hands. And the perception could be drawn from someone looking outside looking in, saying this is a self-sustaining industry, isn't it? Because if we don't get the accurate figures and the fund continues to be solvent based on those figures and employs vast amounts of people and has $1.2 billion in investment, then it's actually in our interest not to get accurate figures. Like to be non-generous.
Yeah, I reject the proposition you're putting, because that would suggest that we're not here and working in the interests of injured people who are victims of dust disease exposure. I think that is not a representation of the way that the people of iCare, the people who are working in the dust disease scheme, behave and act. But I take your point about, well, maybe I'll just clarify, the issue of the number of people in the industry that need to be screened or otherwise has nothing to do with the financial viability of the scheme or to the actuarial process that go to determining the viability of the scheme. It is until that person has defined exposure and until that person makes a claim that the actuarial process would kick in to help us identify a liability for that. And as we heard earlier from Dr. Alsop, this disease, as with all dust diseases, is long-term in nature, and what actually results over time, we're yet to actually find out. So we are in the early days of how this disease will develop for a lot of the participants here. So I think there is a number of factors here that create uncertainty at that end in the longer term. But in terms of identifying the number of people in the industry, that's really not our role. That's the role for Safe Work as the regulator of employers and the regulator in respect to Safe Work sites. That is clearly the role for WorkSafe. We are here to support them through the screening process because we have the technical capability to do that from our knowledge of the diseases, and we are here to support injured people at the time that they need it to get access to the benefits of the scheme. That's our core role. Everything else, I think, is really a question for Safe Work. It's about their role as the site regulator, as the regulator of employers and regulator of Safe Work sites. And I would wish I could give you a different answer, but that's the only answer there is.
Well, Mr. Harding, that's true, that it's Safe Work's job to keep sites safe. It's not your job to be out there to ensure that there's no dust and the extraction fans are working and the masks are on. That's not your job. We agree with that. but it is your job to make sure that any worker that might have been exposed to dangerous levels of silicosis is getting as early a screening as possible. That is your job, right?
We agree, and we are working to the best of our ability to do that in partnership with SafeWork, who are providing us the access to those sites. I think Dr. Alsop again alluded to the fact that we don't have the ability to access sites without the access through SafeWork.
Well, and indeed, even with SafeWork, they can't compel the employer to get you on site. So that doesn't really answer the core issue here. And it's, I suppose, why I started asking questions about that number. If SafeWork comes to you with a number that on the face of it is not credible and says that's the size of the workforce, well, there's no statutory provision that says you can outsource that thinking to SafeWork. You have an obligation to get to as many workers as possible who have been potentially exposed to silicosis. And if SafeWork's not helping, or not coming up with credible figures, or not doing the job they should do, then you have to step up. You accept that?
Well, I think that SafeWork has an obligation, is what we talked about a minute ago, Mr. Shoebridge.
Keep workplaces safe.
Sorry,
Mr. Shoebridge.
But not to identify people who need
Mr. Shoebridge, please allow the witness to finish.
That in itself is part of their obligation, right? So I think we can split straws, but in reality, our job is to work with SafeWork to go out and do the screening. And I 100% agree with you. We are here, and our goal, the thing that we want to do, is to get out there and screen as many people as possible, to identify as early as possible. And, we're happy for your suggestions about the fact that there are different ways to do that. We believe we're getting to the majority of people through the fact that we're doing 3,000 to 4,000 screens a year to get out there.
Well, perhaps, Dr. Alsop, you said you don't notice you'd provide details about the screening. If you could break it down into what the occupation or exposure was of the 3,000 screenings we know, so that we can get some handle on how many of them may be in this Venn diagram of construction work and silicosis. Can you provide us with that?
We certainly can for the last couple of years, yes.
Yeah. And I'll just put one sort of fact check that I've been doing while this discussion's been happening. There's about 380,000 people in the construction sector in New South Wales. I think we could all agree that pretty much every modern building you see has a fair chunk of manufactured stone in it. Bathrooms, kitchens, commercial buildings often have lots more, terrazzo floors, the like. Even if we take the highest number of 1,500 workers, that's about less than 0.4% of the workforce. Doesn't make sense to me, that number. Could I ask you will you be fact-checking that number independently, given you have that obligation to find the workers wherever they are, regardless of what SafeWork is doing? Will you fact-check it?
Yes. To the degree that we can, yes.
And look, you should be being helped by SafeWork in this space. I have no problem with you leaning on SafeWork if they've already done some of the work to identify workers. That's only sensible. But if they're coming to you with a figure that's just not credible, do you accept that you have...
I think
well, that is open to challenge.
Yes.
Do you accept that you have an obligation, independent obligation, to challenge it and test it?
So I just answered the question a minute ago. We will go and challenge it. I think, Mr. Shoebridge, we can all push forward views about how many people are employed in the sector. The reality is at the moment we have no evidence other than the evidence provided to us through SafeWork. And that's the basis upon which we are working.
Or our eyes and ears as we walk around the state and look at building sites. And that's, I think, what's been missing here. But could I ask you just quickly in terms of, is there any mechanism to recover for the scheme against manufacturers, installers or others, as there is under workers' compensation in terms of recovery claim?
No.
And is there any, if a worker brings a common law claim that parallels the dust disease claim, does that terminate the dust disease claim?
No. So that's done through the Dust Diseases Tribunal.
So if a claim's made in the Dust Diseases Tribunal, it doesn't in any way impact on the payments that are made? And do the payments that are made in the dust disease claim take into account the payments in the tribunal, take into account the payments made on the statutory scheme?
that's a question for the tribunal.
All right. Mr. Shibridge, have you got many more questions?
I think that concludes that.
Okay, I was just going to ask Mr. Diadam because I know that he had some questions and I'll offer him the call.
I wanted to ask Mr. Harding, what is the status of the Driscoll report that Mr. Dent referred to? It's with iCare and the Minister, isn't it?
Thank you. Yes. So we received the report in November of last year. And we've been working with the New South Wales Treasury team to, as Dr. Alsop mentioned earlier, we're working on legislation in respect to the remediation issues that we've identified and how we correct those. We are, at the moment, trying to identify the best solution, whether it's regulation or legislative change, and we are bringing that forward with the help of New South Wales Treasury once the government has made its
What are the issues that are being considered in terms of
There aren't any other than how to do it and the timing of it. There's no debate. It's just
no debate. It's going to happen.
It's no
just
debate.
a question about how to do it.
How to do it, and the best way of getting it done, and the timing of getting it done with the other legislative change that's going on. So it's not a question. It's just a process.
Right. And so, what's the anticipated time frame for resolving that process?
Ultimately, that's a matter for the government when they bring it.
No,
forward, but we are currently working with them, and we would
preparation of the advice, and then there's the decision of government.
Yeah. So we are working with them right now. So the advice is happening, the engagement is happening, and we would hope that it gets brought forward very quickly.
So you've provided the advice, you've settled on a model, and that's now sitting with government. Is that the answer? That
we are still working with them on whether we can do this through drafting a regulatory instrument instead of drafting a legislative instrument. But there isn't. That's not going to take very long to settle on. That's just a discussion. Once we've done that, then it'll be in the hands of the government.
Sorry, you go, Anthony.
Okay, all right. I wanted to also just come back to, I think in your opening statement, you were talking about the viability of the fund. In layman's terms, you've got sufficient money with your investments to cover your liabilities, and so I think you said that you were then using that situation to provide relief to employers. Is that correct? Limiting their payments to $70 million a year, I think is what you said. So is that a discretionary call that sits with iCare or the Minister in terms of whether you use those funds to give relief to employers or perhaps supplement benefits to beneficiaries of the fund?
Yes, so we've taken legal advice in respect to the nature of that process and decision, which sits within the discretion of the iCare board as the overseeing body for the fund. If we were to look at addressing benefits, obviously that would need to go back through the government. But in respect to the current process where we are using it to support premiums, that's a normal part of the insurance practice. So the board can
decide to give money to employers, but if it goes the other way in terms of increasing benefits to workers,
the benefits are normally enshrined in legislation. The benefits are normally enshrined in legislation, which is why it would need to come back through the government.
That's not entirely correct, is it? Because is the retraining and redeployment a statutory benefit?
No, that's something we're doing, and in all honesty,
is it discretion to do that?
Mr. Diadam.
So is the screening process as well. In all honesty, that's not something we're legislated to do. It's something we offer because it's the right thing to do. And the assets of the scheme allow us to do that in a heavily subsidised manner. And the position we find the scheme in financially not only allows us to support employers through capping their annual contributions, but it allows us to support them through subsidised screening. We're also looking at more empathetic ways of delivering the entitlements to injured people under the legislation, so we can't go outside the remit of legislated benefits. Not like we can suddenly double weekly compensation amounts. That would be a clear breach. But what we can do is look at how we deliver those in a more empathetic manner, allowing more people access to potentially more of what is available within that legislative boundary.
But in terms of the remediation scheme, what it's identified is that for a class of claims that predate, I can't remember the date, sometime in someone will help me at some point.
1987.
1987, the ability to actually pay dependents for those claims, well, there's probably no legal right for dependents to be paid before 1987. And if we need to fix that, we need some legislative intervention. Well, I can tell you on behalf of my party, we'd vote that through tomorrow if you put the proposal to Parliament.
It's coming.
I'm hoping to get that same commitment from the Labor Party.
Promises you won't even be here.
Well, you've got to do it in the next 2 weeks. Do it in the next 2 weeks. Do it in the next 2 weeks and we'll vote it through. But I doubt. I really do doubt that there would be a single MP in the Parliament that would vote against ensuring that those dependents got the same rights as dependents where the claim is made after 1987. Just get it to the House and we'll get it through, you know.
So if I can just give you some comfort, Mr. Shoebridge, so we haven't reduced payments for people or not paid people who had previously been paid. We're not clawing back anything. So no one is being disadvantaged at this point. We are continuing the current forward. We are bringing that legislation forward. It is with the government. It will come as quickly as we can bring it and as quickly as the government brings it forward.
All right.
So coming back to the retraining and redeployment service, I don't know whether you were listening to the evidence this morning. Did you hear the evidence that was provided this morning?
I'm sorry, we had other meetings. I have heard some short version of it. Yeah, I haven't heard the original.
So, I mean, there was Mr. Clark's evidence was that the service is pretty inadequate and that it was making, recommendations that were clearly inappropriate to his circumstance. Perhaps on notice, given that you haven't heard the evidence, you can't really make a comment about the specifics. You might be able to provide some feedback on those observations that were made by Mr. Clark. Is the service directly provided by ICARE, or is it something that you've contracted with someone?
Yeah, we have third-party providers that we engage to deliver the service.
In terms of just describe in a bit more detail the nature of the assistance that's provided, and the extent of the support that's provided for retraining and redeployment.
Absolutely. Perhaps if I do it by way of an example, and so I'll change names to protect the identities of those involved. But we have an injured worker identified through our screening program who has 1% silicosis diagnosis and understandably very concerned about this. He's an immigrant to Australia, English not his first language, has a family to support and has been earning really good money as a stonemason. So following his screening and identification as having that 1% impairment level, he's understandably concerned about everything he's heard about the risks and very afraid for not only what that means for his health, but how he will support his family into the future as well. So in the support that we provide through iCare, we're able to put him in contact with a vocational rehab specialist. Now, this person, through the use of a translator service that we also fund, sat with the individual, let's call him Tom, say, and worked through what his career goals would be outside of the stonemasonry industry. And through the course of that, it was identified that he had a passion for forklift driving. So it was something that he was really interested in pursuing as a career. So the rehab consultant then worked with Tom to identify appropriate training programs to give him access to the right skills to move into that career. He was supported by iCare in accessing those programs. We funded his access into the training required and then supported him again through the rehab consultant to identify potential workplaces and apply for roles with those workplaces. Very pleased to say that Tom is now happily working as a forklift driver, has left the stonemasonry industry, is continuing to provide for his family and is continuing to be regularly rescreened through iCare's services free of charge to ensure that should the disease that he has unfortunately progress, he's provided with the right information and the right support to be able to continue his life and continue supporting his family. So the service is holistic. It does try to address the needs of every individual. I will say that it has only been running for a relatively short period of time because this is a new cohort of younger sufferers that have been identified in recent years. Whereas I think I mentioned earlier, most of the people that came to the scheme in the past were beyond retirement age, so did not require vocational redeployment. So
And there's a wage top-up, is there, as part of it?
if the occupation that the person moves to pays less than what they were earning in their previous occupation, yes, there is.
So does that create a financial incentive for iCare to find a worker an alternative position? Because ultimately, if they're on statutory benefits, then it's an ongoing cost.
I wouldn't.
Whereas if they're redeployed to another industry where they're able to work, that cost then ceases for iCare.
Well, it's in everyone's interest, isn't it? To get a worker back.
I would think so. Yeah,
It's in all our interest to help people get back into the workforce in the best form that we can. Whether that means that we continue to pay a top-up payment or not isn't really the point. It's about getting people back into a workplace where they can have...
I suppose that where I'm going with that is does it then create a dynamic where workers are pushed into taking on positions that perhaps aren't necessarily suitable, which seemed to be what was suggested in evidence earlier today?
We have no evidence of that happening. In respect to the evidence you heard this morning from Mr. Kolk, we'd be very happy. Obviously, individuals have different experiences through the sort of process that Dr. Alsop's just described. Very happy to talk to Mr. Kolk and try and work out what happened with his experience and support him in whatever way we can. So that's our job. But to your point about is there a systematic problem where people are being pushed into jobs, I don't believe that's the case, and there's certainly no evidence that we can see of that happening.
And the case management
on a systematic basis. I mean, it may be an individual issue.
iCare, is it? It's iCare actually do the case management directly. It's not done through a third-party provider.
That's correct.
Just on that quickly, the 1% impairment finding, and I've got to say I think that's been a positive change in the way that this area has been dealt with because it allows those services to be provided. Does that also allow for the payment of a full statutory benefit while having that work, while looking for work?
Yes, it does.
And all right, good. Is there a need though for some clarity, some legislative clarity in this space to make it clear that if a person with dust disease has to transition out of an industry, that the payment is payable regardless? Or is there sufficient legal clarity to allow for the 1% mechanism to work?
We would always be happy to explore additional legal clarity, especially when we're dealing with acts that go back to 1926. So, have you made representations to get that kind of clarity? Not as yet, so it's not part of the current legislation that's being drafted.
Is it something that at some point you'll put to the board, Mr. Harding?
Well, look, I think we're happy to take the feedback on and understand it. In terms of the current situation, we don't see any evidence that there's a problem, right? So the 1% mechanism is working. We're seeing that happen. Happy to have as much feedback as you like, Mr. Shoebridge, so we can take it on. We are welcoming it, not resisting it.
I'll just indicate looking forward. It's nothing you'd want to lift the bonnet up and look too closely at, and there might be actually a benefit in getting some legislative clarity in that space going forward. But in terms of reimbursement...
Is this a single question? I was just going to...
It goes back to a point that I heard some evidence on, which I think... The Dust Disease Act actually does, I think it's Section 8E, reimbursement of compensation from negligent third parties. It mirrors the 151Z of the Workers' Compensation Act in terms of recovery. Have you brought any recovery claims under 8E? And B, have you considered whether or not you can bring recovery claims from the likes of Caesarstone and others, which have no insurance in Australia, to cover their product?
think we'd have to take that away on notice and come back to you as to whether or not there've been any of those sorts of actions.
And do you accept, though, that given Caesarstone is the largest player in the industry and has no insurance cover for their product, that may make any recovery claim that the scheme has potentially worthless?
I don't feel qualified to advise on the financial soundness of Caesarstone.
Is that a decision?
Well, have you...
That's not something we can provide advice on, Mr.
Given it's the biggest player in the industry and their own filings with the US regulator make it clear they have no insurance cover for Australia, there hasn't been any kind of analysis by ICARE about whether or not that creates an unfunded or removes a potentially quite valuable right from the scheme?
We will focus on providing compensation to anybody impacted adversely by a dust disease in New South Wales. Recoveries are a secondary aspect to that.
But it's a part of the scheme, and in the end, if you can't recover it from the negligent player under 18, it's met by all the non-negligent employers who are doing the right thing.
Mr. Shibbridge, I think...
There's
a moral hazard here.
Mr. Shibbridge, Mr. Harding had the call.
Sorry. Look, I think we aren't qualified to answer the question about, as Dr. Allsop just pointed out, the financial soundness of a stone manufacturer, a global stone manufacturer. The recovery issues will arise as the liability arises. The fact that they have no insurance in Australia doesn't necessarily mean they aren't able to meet their obligations if there are any. That's a different question. Again, there is no current evidence to suggest that. I don't know, because I don't know what their balance sheet looks like. I have no view of their support they might get from their global parent. It's a question that we're unable to answer.
No assets in the jurisdiction and no insurance in the jurisdiction. We're at the tender mercy of Caesarstone if they want to keep paying the claims. Maybe you're happy with that, but I'm not. And I don't think the scheme should be.
Mr. Shibbridge, I take it that really wasn't a question, but I'm going to ask one on that related point, if that's okay, before I pass to the others, just noting there's about 5 minutes to go. Putting the issue about Caesarstone aside, has there been any attempt or any investigation about the recovery from any manufactured stone importer, provider, manufacturer into the scheme to date?
No.
Should there be?
We can look at it, yes.
Is that a decision that would be made at the board level, or how would that kind of recovery decisions?
Ultimately, we would put a recommendation as a management to the board about making that recovery if it was appropriate to do so.
Deputy Chair, I know you had a few points. I can see that... sorry? Well, Mr. Kane, I'll go to Mr. Buttigieg, Mr. Diadam, and then Mr. Shoebridge for a clean-up in the 5 minutes we've got left.
I might just take you to the stats which we did, I think, touch on earlier in evidence. This is in your submission. There's a table of a breakdown of new cases of silicosis and silica-related dust diseases for financial years 15-16 through to 21-22. I think one of you put on evidence, maybe in your statement, that the cases had gone up from, new cases had gone up from 9 to 40. That was from FY 17-18 to 18-19, I think, from the looks of the table. Does that sound right?
Yes.
So can I ask, in terms of those new cases, what is the definition that falls into to satisfy a new case? Is it a workers' comp claim or a screening test, or?
It is claims accepted into the scheme through the medical assessment process that determines eligibility for compensation.
Okay, so if a person doesn't make a claim, then in terms of the statistics, they don't have silicosis.
They don't have silicosis and are being compensated under our scheme. Yes, that's correct.
So I'll point you to, there's quite a significant jump from FY 18-19 to 19-20, almost threefold. And then, so these are claims. let's be clear, these are current claims, right? They're not historical. So these are new cases. And then there's a drop-off from FY 1920 to 2021, from 107 down to 37, and then this year, which is anomalous because we're obviously only a quarter into the year or whatever it is, down to 9. But given the advent of COVID, would that, and let's take out 21, 22, but if you just look at that drop off from 20 to 21, would the advent of COVID affected those figures, given the restrictions on people?
There would be some small impacts, yes, because of the closure of our screening services. So that will have flown on to fewer people passing through the medical assessment process than might ordinarily have been the case. But we don't anticipate that was material. It has been more material in the last 9 months, where we've had services closed for about 5 months.
Yeah. So is it possible we could see the likes of that 107 peak in 1920 happen again, or even an upward trajectory?
I think it's highly unlikely. I think what that peak represents is the early identification of a fairly significant number of people who had no symptoms of silica-related disease and would not ordinarily have presented for screening or even been concerned potentially about their exposure to silica dust in the workplace. So the intensive screening program focused across manufactured stone and tunnelling and various other industries where silica exposure has occurred has drawn out and identified early a number of people who might not have been picked up by the scheme for another 15, 20, even 30 years. So I think bringing those forward is absolutely a good thing. It's given people awareness, it's given people information to help manage their own health outcomes, as well as be supported by the scheme and potential retraining, deployment to other industries, those sorts of things. But because they've been identified early, I don't anticipate we'll see that level of spike again, because we've kind of picked up a large number of people who might have come through in a much slower fashion as symptoms emerged into the future.
Mr. Buttigieg, have you got
just one very quick follow-up? My recollection is that that's somewhat counterintuitive given what we've seen, for example, in other jurisdictions like Queensland, because I think the more proactive they got, the more the figures went up. So it could be a case, couldn't it, that the more proactive we get down here, you could actually see quite a significant rise, as you did in that particular year.
I think
so. My question is are we a little bit blasé in being comfortable about this thing stabilising, given the veracity of those figures and the underlying?
If I can jump in, look, I think the reality is the numbers are very small. The volatility in the numbers is high. It isn't something that you would form predictions on the basis of. We're not suggesting it's stable. We're just suggesting to you that we believe that the 107 is a result of the proactive work in the screening that was done prior to that. Where it rests as an ongoing thing, I think, is yet to be determined. We don't expect it to increase significantly because we believe we've brought a whole lot forward, but that will develop over time. To your point, that will develop over time as people's exposure and their issues grow.
You accept as a general proposition, though, there's a positive correlation between the degree of proactivity and education and exposure of the issue and the case numbers?
I'm accepting that the 107 spike is directly referable to the increase that we did in scanning and screening and being out in the community with Safe Work New South Wales.
Mr. Dowdham, you've indicated you haven't got any more, is that correct? Mr. Shoebridge, have you got anything that you want to brush up on before we call quits?
No, I think that's it. Yeah.
Thank you, Mr. Shoebridge.
If I may,
yes.
Just to provide a point of clarity around the recoveries piece, because I know that was a focus. It is, in fact, the Dust Diseases Tribunal that has the rights of recovery under the Act, not the Dust Diseases Care Scheme. So it's not our role to seek recoveries from those manufactured stone sites or other employers in the industry. It's the tribunal in its dealings where that occurs.
Thank you for that clarity, Dr. Alsop. Well, on that note, I will call this hearing to a close. For the questions that have been taken on notice, you'll have 21 days to provide a response. And once again, on behalf of the committee, can I thank yourselves and also all the other witnesses who have actually appeared today. The testimony and the evidence has been very valuable in us generating this report for what is the final statutory review for this term of the Parliament. With that note, we'll call the hearing to a close and thank everyone. Thank you.
Thank you, Chair.